Anandya, who is the resource person now? Is your class or Murali's class?
Sir, she is already there.
Oh, Murali is already there.
Yeah.
Yeah, good. You got his biodata?
Not yet, sir.
Oh, you should have asked now. How do you introduce?
Okay, sir. Should I start?
How many people have joined? Only 51.
Yeah. But if we
Okay.
delay, sir, it will be delayed on later on also.
So it's around 59.
Hmm?
60 people.
What, Ravindra? You're saying something?
Right now, 62 members are there, sir.
60 are there.
Yeah, 60 plus.
Yeah, just wait for 5 more minutes. 5 minutes more. Okay. If you all allow, we will wait for 5 more minutes. Otherwise, we can start also. There is no problem. As the speaker has already joined. Murali, did you join? Murali?
Okay, ma'am. So as sir is saying that we will wait for 5 more minutes.
Yeah.
After that we will start.
Good afternoon, sir.
Yeah, good afternoon. Good afternoon. You have joined, no? You are ready?
Yes, sir, we are ready.
Okay, good. Just another.
I'm ready, sir.
You are ready. Okay. Just let us wait for 3 more minutes. Yeah, Prasad Garu, what do you want? You want to raise your hands? So all of you, please mute your mic and as I was telling you, interact. You learn more through interaction rather than listening. You know, my experience is that the actual learning takes place through classroom is only 30%. But the 70% of learning happens only if you ask questions. So by asking questions, not only you learn, others also will get an opportunity to learn the new concepts, to clarify their doubts. They also may be having the same doubt. Many times what happens, people hesitate to ask questions, but they get satisfied when somebody asks questions. And many times we used to feel, yeah, the same question I was also having in my mind, but someone has raised it, so I got the answer. So that way, some creative people, some people who have that kind of a passion, courage to ask questions, it not only benefits you and it also benefits others. you know so what more happiness you can get by raising questions by yourself, not only satisfies your queries, it will also help others. So helping others is also a great tribute and great value and great contribution. We may not be able to help directly many times to people, but if they get indirect help, by through your question, it is a great help, for others to enrich their knowledge. So please make use of this opportunity and raise questions without any hesitation. That is what is very, very important. Okay. Our session should be different compared to the remaining classes what you might have attended earlier. But always I emphasize, I prefer, and I motivate all of you to ask questions. There will be so many questions. If you listen the class carefully and you put your mind, apply your mind, to learn more, there will be n number of questions. There is no dearth of questions to ask. But only thing is what is required is your openness, your unbiased openness is very, very important. You have that, you will be able. That is how we all acquired knowledge. We also studied like you, the BTech, BSc, MSc, or PG. But how we acquired this knowledge, how we reached to this level, in our careers, in our lives. This is all because purely, you know,
Hello, ma'am. I think sir got disconnected. Am I audible, ma'am?
Yes.
Okay. So, participant student speaker is in front of you. She is Dr. Kavita Poddar from Questel Orbit, India. She is the senior IP director there at Questel Orbit, India, right now located at Bangalore. She has got rich experience in whatever you will be learning today, that is pattern search. So she will show pattern search, how you can do in your research or in your project. Please pay attention so that you can utilize the skills that you are going to learn here in this class, and that we hope that it will be really useful for you. This is the tutorial that we are doing today only. Yesterday was only the theory class. Today you will be having tutorials. So thank you, ma'am, for joining. The floor is yours, ma'am. Thank you.
Thank you. A very good afternoon, everyone. Thank you for your invitation and introduction. It is an honor and a privilege to have the opportunity to contribute to such a wonderful initiative in IPR. I know Dr. Purushottam sir since when he was in NRDC. So I think I have a relationship with him, means knowing him since last 8 to 10 years. And I have been in this field since last 15 years, and I have experience in pattern search, as sir was asking to ask questions more and more. So really make it ask questions, but all the questions would be around pattern search. Okay, because my experience in that only. So let me share my presentation. Can you see my presentation?
Yeah, yes, ma'am.
Okay,
Yes,
great.
ma'am.
Yeah. So the topic is unlocking innovation and benefits of patent searches for universities, where I'll introduce the patent search platform, free and paid database. I know everyone had joined after lunch, so sometimes it's a sleeping we feel. As sir told multiple times, ask question, ask question, ask question. So make me even awake and make yourself awake as well.
Ma'am, I don't think the presentation is visible. It's not visible at our end.
You
Your
have
screen is
shared
visible,
your
madam.
entire
PPT is not visible. Your screen is visible.
not yet.
Okay,
Yeah.
fine. Now it's visible.
Not yet. Just sharing.
Okay, just a minute. Stop sharing. Let me check what all the options are there. Now, is it visible?
Yes, ma'am, it is.
Yeah.
Presentation
Yeah,
is
But
visible,
it's
right?
visible, madam.
Yes, ma'am.
so with
Okay, good. Thank you.
hard copy.
Oh, so first let me introduce my company. My company Questel. It's a French company having offices in 30 countries globally, including New Delhi. Basically, we are the global provider of tech-enabled solution, IP related, where we deal with all the IP facets like patent, trademark, industrial design, and other related services related to IP. So since we have been providing this database since more than 40 years. So it's our duty is to provide the most secure, and we have some corporate social responsibility. So our data is very much secure, ISO approved, and we follow the high standard for all the solutions there. The company started in 2001 and further with the LBO. In last 5 years, we have acquired 18 different companies related to IP patent only. So now we serve end to end, either it's a patent data, trademark data, industrial design, or any kind of services, foreign filing, translation related to patent, and any so many different kind of things are there in that area. So let's start the session. What is patent? I believe Dr. Purushottam might have taught you, or you might have already session on that. So I'll go very quickly on these part. So if you see this shoe, there is an additional design, figure 4 is added that helps person to stand and incline in one direction. So basically, patent is an exclusive right given to an inventor who submit their invention to the patent office, depending on certain criterias. Like each patent office is having the certain criterias. If you are following all those criteria, the government will grant you patent, and that you can use further. That will be exclusive right, and that's a limited right also, I can say. It's a negative as well sometimes, because whether you are manufacturing or not, those things, but you are debarring others to manufacture. In the case of limitations, very much territorial. So when you are getting the rights, you are filing the patent application in India, you will get only rights to do things in India. If someone is doing in China, you cannot stop them. So this right is territorial. So basically, you are preventing others to making further manufacturing, selling further, or importing, or doing the licensing. So you will have the rights till 20 years. That's a limitation. And in the country where you seek the rights, so that's the limitations. What can be patented? So in this cartoon, if you see, one person has invented big wheel, but the another person has invented a small wheel. So the other person is saying it's a totally different product, no infringement, but nothing like that. There is a one component which is obviousness. So any skilled person can work on that and get and reduce the size of that product if it is there. So there is some basic criteria given by government, and you need to follow that. If you are fulfilling all the criterias, your application will be granted further. So those criterias are novelty, everyone knows. It should not be published in India and anywhere else. When we talk about the right, we say limited to territory where you are seeking the rights. But when we search, it is global search. When we look for the novelty, it is globally. So not only India, even it is published in some other part of the world, you will not get if patent examiner has identified those. So make sure it's novel, you are not duplicating existing things. Then non-obviousness, obviously invention should not be obvious for the skilled person in that particular technology. And then it's come industrial applications that you can reproduce
Ma'am,
further.
just,
Yeah. Yeah, sorry.
sorry for
Yeah,
interruption here, ma'am. Here the novelty, the scope of the novelty is in the territory. Yesterday we have learned it. So now the scope is expanded to the globally. What exactly the difference between these two?
Yeah, so it's always
The
globally.
one, the patent in one territory, will it applicable for the global?
No, so that's a right. You're talking
Not
about
right.
the rights. Yeah. So
Right.
right is
Okay.
not
So
applicable in other countries. Yeah. But novelty search,
so you're talking
whether
about
your
invention.
invention is novel or not, that's a globally you need to check. It's an
Okay,
internet
fine.
world, right? Anyone can gain idea or something in US and come back in India and can claim it's mine, but actually it's not, because every world is connected right now, right? So novelty is global, rights is territorial.
Yes, got
Okay.
it.
Yeah. And the fourth point is inventive steps, obviously technical enhancement as compared to existing knowledge. So that makes patent different from other IP field. If you talk about the trademark, if you talk about the industrial design or copyrights. So in patent, it's a technical enhancement. If you come up with some ideas and if you feel ki it can be patented, no, if there is no novelty, no technical enhancement properly with existing in compared to existing invention, you will not get patent over that. Why to perform searches? So as we said, keep novelty, you need to know the novelty. Sometimes you do Google search here and there and you feel, or every inventor, every people who does invention, they feel ki their invention is very unique, very novel, but it's not like that. So we need to perform the searches. So first of all, if you have any idea, you got some technical field where you would like to work there, and if you have the database and you know how to do the searches, it will give you the eye view of existing technology or similar technology. So that will help you to improve your invention, improve your work further, and come across with the novel features. It also, the database also reveals the company's competitor, like which all companies are working in this technology, which all competitors are working, which all other universities in the world working in that direction, whether we can collaborate with them. So those information you can get from patent database. It gives commercial value as well. If you feel your invention is very unique, the commercialization, you need to understand the value of your invention. So that depend on various factors. When you do the searches, you come across, okay, these are the various factors my invention is having, and on that basis we can get the commercial value and negotiate further. It also gives the possible infringement in future. For example, if you are working commercially in some particular technology and you don't know okay, whether it's already someone's right, someone's exclusive right, and you are doing it further, you get the notice of infringement. So that also gives you, like database gives you the possible infringement in future. So you will be aware before filing the patent or before going to the market or commercialization. And obviously you check the invention whether it's a patentable or not. As we said, these are the criterias. Obviously non-obviousness, inventive steps, these things you need to understand, but novelty you can check through the database whether it's a patentable or not. So patent is most reliable sources. Most of the universities in India, they do the searches, but they do general Google search or they do non-patent literature search because they have good access of most of the technical journal. So they do the searches and they feel that their search is exhausted, and whatever they come across with the technology and they develop, it's a unique. But trust me, most reliable sources is patent. 80% main technical data comes from the patent. So make sure if you're going ahead with your invention or any ideas further, make sure you are doing the patent searches, either using my free database or paid database, doesn't matter, but you make sure you are doing the patent search to establish your things, you know, this is really novel and these are the technical enhancement, no one has does these things and I'm ahead of them. So very latest information it gives, but even latest information, there is a lag of 18 months because when you file the patent, it takes 18 months to publish. If you go for earliest publication, then only it get published early. But 99% cases, it gets published in 18 months. So there is a gap of 18 months even there. So you have to make sure that there is a gap of 18 months. So you are doing other kind of searches as well to make sure that your patent is carrying the novelty. And available free of cost in many sources. We will discuss these things in sources. Can I ask someone to take the questions in between, because I'm concentrating on PPT, so I'm not able to see the questions. So anyone can speak out the questions, I can answer it if anyone is
Oh,
typing over that.
Ma'am, here the question like what about this race condition? So as we know that the first patent is having published will be published in then after the 18 years, right?
18
So
months.
18 months, sorry, just 18 months. In this the same period of time, some other party A or party B has published apply for the patent. So, so what criteria will be given for the patent? Who will be the getting patent on that?
Yeah, so first filing, whoever has filed first, that person will get. But your query is very good here, like whoever has asked these questions, there is a gray area, there is always a gray area. For example, if any examiner, even they are checking the novelty, they can only check the data which is available to them. If it is not published, they cannot check the data. So there is always a gray area or gray things. But if someone further, that's why when we publish the patent applications, when a government published it, it opened for the public to check. So being a competitor, if I'm working in your area, being a competitor, I'll keep an eye on each and every publication on that particular technology. If someone has published, I can say कि mine is already filed. Maybe it's delayed in publications, but it's already filed, and you can show the application date, first priority date, and you can claim your priority there.
You meant to say that the date of application
Yeah,
will be the
first
first.
filing date.
Yeah. Okay.
Yeah.
Got it. Thank you.
So, what benefit in university you can get doing the patent search? I think Dr. Pushottam is doing a wonderful job there, but everyone need to understand. People generally have IP team, they file the patent, they get it done outside sometime prior art searches, and they file the patent, and later on they come to know so many problems are there. So if students or faculties are well versed of patent searches, what all benefits they can get? So first of all, research and innovation. You know, universities is hub of innovations. So conducting the search will help the students and faculties to come across the latest technical technology published in patent database. So they can make sure that they are not duplicating it, and they are further developing novelty over that, and then going ahead for the patent publication or patent applications. So it will basically fulfill the gap between the existing technology and could be the further developed technology. The next one is technology transfer and commercialization. Being in university, that's a prior commitment for most of the dean and universities. If we have any assets, we have any IP valuable assets, then we should commercialize it. Everyone wants to earn money on that basis. That's the criteria followed by most of the top 10, top 20 universities worldwide. If you see the big universities, like most popular universities in US and Europe, you will find they commercialize their patent technology a lot, and we are much behind in that things. So how patent search will help? If you have any patented technology, when you go for the commercialization, you when you are discussing with your potential collaborator, you can present them the value of your invention, how it is value, what is the market value, the coverage, so many things. You can present the landscape of that patent in compared to the existing patent, and what enhancement you have done. That will help you to negotiate further and get the better value. The third point is prior art search, which I have been discussing, that novelty search before filing any applications, because patent filing is a costly affair. Just a first application filing is very, I can say, government is providing at competitive price. It's very cheap. But further, if you go ahead, with that application, like if you do the drafting will cost you a lot, and then a lot of steps are there. If you maintain the patent, a lot of things are there. So it's suggestible ki first you do the prior art search at your level, then go ahead with the attorneys and file the patent application to save further time of universities and money as well. And then it's come a strategic planning where universities, when they make a strategy to allocate the budget, raise the fund, which sector they have engineering background, where the people, like within the limited sources, what all technological area they can work within the universities. So that also help you by the patent search. You can get help from the patent search, where you can make out ki what all the technologies are there, which all university can work. So that's, you can make the strategic planning by having the patent landscape of that particular technology. You can range the fund further. If you present your invention properly, then you can raise the fund. And when you go for the fundraising, there are a lot of questions technically, so that the database will support you with the background, with the more information, so you can convince them better and get the better funding. Further, you can collaborate and partnership with many either universities or big companies. If you're working, how will you find out if I'm working in this particular 5G technology, whom I should approach in India? Who all are finding? Who all are doing the citation? Who following me? So those things, a lot of small things are there. When we work on that, then we find out the best collaborator and we work with them. And obviously ips strategy means sometime being in IP cells, people like a student or faculty come up with their technology and they say it's a novel, we would like to go ahead with that. And then team perform the patent searches that they come across, okay, this technology doesn't have industrial application maybe, so there is no point of investing money over that, but this is the very novel one, so maybe we can just publish it in open domain or any journal, or we can keep as a know-how, or we can keep as a trade secret. So those kind of a strategy can be planned. Informed decision can be taken using the patent database. I hope I'm clear on these points. This is just I can say it's a pictorial way of presenting when to perform the searches. Sorry, when you have the idea and you want to compare with existing invention, use the database. When you're doing the R&D, you are developing your idea further in prototype. Then you need to work, get the database. When you're filing the patent for the novelty, you need to search in database. When you're commercializing, collaborating, then also you need to do the searches to support your point of things, what you are presenting further. So the further we will learn what all data, what all information we get in patent document. So for example, you are searching, what you are searching, how you are searching, why you are searching. And you need to understand what is the meaning of these terms. Then it will help you to search in better way further. So this is bibliographic information of US PTO publications. If you see say it further, it's giving the title in abstract. Title means whatever the invention is there, it gives the one line information. Abstract, that gives little bit more content or concise summary, you can say, of that invention. And then applicant, inventor, who all has filed the application. So in India, mostly inventors are who develop the technology, but applicants are either the universities or companies under whom you file the technologies. These are the bibliographic data. Application number. So application number, when you first file the applications, that gives the application number. Government always gives one unique number, that's application number. Priority number, sometimes it's the same of application number. For example, if you have filed patent application in India first time, then both the number will be same. But claiming that number, that application number, you are filing that application in other countries, then for other countries priority number is Indian number and the application number is their own country's number. So it differs if you go for the second filing, but the first filing it's the same. And publication number, when it published, then government office gives another number, because many patent didn't get published, so to make the differentiation they give the publication number. Even they published 2-3 times, each time either they change the type of publication, like A, B, sometime Z, sometime there are different kind of publications type. So according as per the country rule they provide, or they remain the rest number mostly same. Dates is also important to understand. What is filing date, priority date, and publication date? If you understand the number, you understand the dates easily. So filing date, when we file the patent in any countries, they that's a date. The first date, first filing date is the priority date. When we file subsequently in subsequent countries, then priority date always remain the same, and filing date keep changing as per the countries. Publication date is also different for each countries. In classification, there are many classification earlier, like IPC classification, international classification, there are US classification, EPC classification, and then Japanese classification, F1, F-term. But now we are moving in that direction where two main classification most of the globally like countries follow. First is IPC, second is CPC. IPC is given by WIPO, International Patent Classification. CPC is Cooperative Patent Classification, given by it's jointly by USPTO and EPO. So most of the new invention, that new application is getting published. Most of the publication is having the CPC classification now. Any questions? Yeah. And then it comes to the description. When we talk about the description, basically, sorry, any question?
Ma'am, just there's just a confusion between the priority date, the application number, and the priority date. Application number is clear. So in the priority, actually, there's a little bit ambiguity. I mean to say that suppose the first filing date is the application date, right? Yeah, and then the priority is that suppose we filed an application in India, is the priority one. Suppose if we file the same thing in UK, or second thing, so then priority will change. So what is the priority there? This I couldn't
Yes,
understand.
priority will never change if you file the patent application in India.
Yeah.
So within the 12 months, if you're filing that same application in UK,
Both
or
countries.
there is a PCT rule, yeah, PCT rule. If you file through the PCT rule, you will get 30 to 33 months to file the same invention in UK. If you're filing in UK, you're always claiming, I have filed first in India. So the Indian date or Indian number is a priority number or priority date. UK number, UK will give you, when you file the application, they will give you one number or one date. That's the application date in that country.
Okay, the priority will be independent to the country.
Yes, independent of the country.
Okay. Got it. Thank you.
Only thing is we repetitively file the same invention in different countries. So that's why there should be one common thing to connect everyone, right? Every invention, the same invention everywhere.
Yes.
So we're connecting with priority. Priority date and priority number is the one thing which is connecting point for all the family member of that patent.
So in this case, data is exchangeable for both the territories.
Yeah, so application date is different from both the territory, na?
Mhm.
I didn't get your questions,
No,
might be.
I mean to say that you applied in India with a
Uh-huh.
priority one. And the
Mm-hmm.
same time, actually, we applied in UK for the patent, and there will be another priority. So maybe,
No, so they should not, means if you're claiming the different priority, then invention is different. If the same application you are filing in UK, you have to say ki you have already filed in India,
okay,
and that's a priority
okay,
number and priority date.
got it now.
You cannot file the application separately, independently. If you file, that second application will become prior art for your own invention. If you're not claiming the priority of India, because there is a gap of 1 month, 2 months, 3 months, whatever gap is there. So the UK application will get abandoned because of your own, you are citing own patent. You are
Mhm.
killing your own patent.
Okay, got it.
Yeah. So further description. Description is the one thing where when anyone read that patent application, a specification, they can understand what exactly the invention is. So first of all, we write background of invention. So we mention ki what is the technical background, what it refers. If there is any prior art, you can say ki this application number was published, where this information is there, and what extra you are providing the information. So that's a background of invention. Then summary of invention we give what all the new things we are claiming, and then drawings description and detailed description. So the purpose of detailed description, if it get expired, because it's a limited rights you get only for 20 years. So after 20 years, when it get expired, anyone can use the technology and produce or use that for the manufacturing or for those things. So detailed description need to be given there. So if you find any similar patent which talking about the same thing what you are going to claim, if you, because sometimes title doesn't give the exact information, abstract doesn't give, somebody doesn't give, so you need to go through the detailed description and to understand the invention in proper way. So this another thing is claim. Claim is very very important of any patent document. It's basically legal boundary. You create a legal boundary where you claim what, because in description you explain so many things giving the example, but in claim what exactly you are claiming, what enhancement you if you have done. So claim is very very important to go through of any document. Even being a patent searcher, we don't focus much on description, we focus on title, abstract and claim, because claim is the main part, main body, legally bounded body, that's showing the exact enhancement, what exactly they are claiming, what exactly they have done the new things. So claim is very important. As a legal term, independent claim and dependent claim. Independent claim is basically first claim that is that standalone you can claim, and everything is dependent on that. If you're saying this particular filter is having a consisting ABC component, and then further you are describing independent claim ki A component is consisting of these things, these materials, B component consisting of these materials, C component consisting of these materials. So dependent claim is always depend on independent claim. So while being a patent searcher, you have to check the independent claim mostly, and then dependent claim, because dependent claim is already presenting the independent means those feature, those component, those particular words are available in independent claims. If you're not getting an independent claim, then you can search in dependent claim. So either you search an entire claim, or sometime if lot of data is there, people restrict to independent claim. So now I'll come to the family member, as there are a lot of questions. So if you see here, first we file the India application number. Same application number will become the priority number as well. And then you file the same patent within the stipulated time. Either it's a 12 months or 30 to 33 months, depending on which route you are going, conventional or PCT route. You're filing in other countries globally, then those, like if you have filed in Japan, China, US and Europe, this everything will come under the family member. So if you heard about the patent family, means same invention published in different countries. So it's a very simple family grouping. It's easy to identify. There is only one priority common, and other countries it is published. But there is another grouping which is called extended family. That's also called INPADOC family, because this definition is given by European Patent Office. So many times, being a searcher, we also check if it comes to the invalidity or validity or FTO kind of things. Then we are more means strategically we check okay, let's see if there is any extended family which are claiming the same invention, and I can invalidate our competitors invention. So in those cases people look for the extended families. If you see here, document 1 is claiming priority 1 and document 5 is claiming priority 3. So there is no direct relationship between document 1 and document 5, but they all are indirectly connected to each other. So that's why it's called extended family. Very normal terms, if you say, like parents and kids are family, all cousins are extended family. So in the layman language. So if you see, this is the same invention, simple family. If you go for the similar, there's a small changes. In India, even sometimes we file the additional patent. Additional patent means after first publications, you realize that this component need to be more having the good features if we add another material. But it's leading towards the same invention, same technology. So if you go independently, you may not get patent right. So the examiner suggests, okay, you file the patent of additional patent, saying you're claiming the same priority, first priority. You are not claiming the new one. And you are saying we have filed the application number in this particular year, and there is something, and I have this claim, but this should be in the scope of one invention only. Just you are enhancing some technology. So patent addition also considered as a same extended family sometime, or simple family, but since it is same priority, it's mostly come under the simple family. Any questions?
Ma'am, here, where is in the extended family, where the enhancement or advancement of this similar or same kind will be claimed by the same owner, or maybe on the different owner?
No, it's always same owner.
Same owner. Okay, fine.
Yeah, mostly 99 point. But if there is a change in ownership of the same application, because sometimes we sell our patent to other person also sometime now. So that's, there may be differences, but it's the same.
Yes. Okay.
Yeah. In US, there is a lot of rules, actually, continuation in part. In Japan, continuation in part. In US, you can claim 2-3 priorities. Lot of things are there if you go ahead further. So that's why extended families are there, because they are talking about the almost same technology, but they are claiming different priority. But there is a common priority. If you see, everyone is having some common priority to each other. And then citation, which is very important part to understand to do any kind of searches. So your application is this, you have filed the patent application. When we are discussing about the description, as I said, background of invention we need to give. So when we give the background of invention, being an applicant, sometimes we quote some patent application number. Okay, this USPTO, this US 234500 is claiming this, having this, and we have done the we are claiming this. So that's a background citation. Sometimes examiner also give the background citation. Like examiner come across while examining your documents, they come across with some typical invention which claim 2 is very much matching to your claim 5. So they give back, but you successfully convinced him that they are claiming, but my claim is little different from them, and that's increasing the efficacy in the technology. So that's the examiner citation. So applicant and examiner both give some background. So that's a background citation. After your publication, someone will also cite your application. So that's a forward citation. So after you, anything has published citing you, that's a forward. Before you, anyone has already published and you are citing them, or examiner is giving that, that's a backward citation. So backward and forward citation you need to understand. When I was talking about the strategy, when I was talking about the commercialization, negotiation, this citation plays very big role. If your any invention after 4 5 years, if there is a few citations, that means your invention is really good. If there is no citation, or even if backward citation is one or two, and then your invention, if backward citation is 10, that means 10 different technology you are citing and coming across with the new technology which having the 10 different benefits with additional some benefits. So that you're broadening your technology, you're broadening your classification. If your backward citation is more, if someone is citing you more, it means your technology is breakthrough invention and people are citing you and developing further. So citation is very important in this field when you do the searches. It's a graphical representation here in below where one WIPO application and how it is backward and forward citation it has shown. I believe this is clear to everyone. These are the drawings. It's very important, especially in mechanical field. When you do the searches, you don't have time to go through description. Title you can just read. Maybe title is very common for most of the similar technology. But when you see the direct drawing, for example, in the same technology, you are working on some technical enhancement in the tire. So just by seeing the tire, you can check, okay, the number 30 and 31 is explaining about the tire. Directly do the control F in description and claim, and you check what exactly they are claiming in this tire. 30 and 31, what inventor or applicant has described about this. Whether that description is similar to mine, what I am working, or this is different, or how I can enhance. If they are using some rubber material or some different material, what material I am utilizing in that particular features. So for mechanical field, the drawing is very important to know, and just seeing by drawing and further giving the reference to the description, you can identify the best relevant patents there. Some legal status you need to understand being a student. There is basically two things, alive and dead. When we talk about the alive, then which stage it is, your application. If it is pending, it means you didn't get the patent right yet. If it is granted, then you got the patent right, and you can debar others, you can work on commercial part and so many things. If it is dead, you have to make sure, like as I said, keep after 20 years anyone can use. So if it is dead, there is a various reason of dead, not only 20 years. It may be abandoned by applicant. If applicant is not maintaining the patent, they are not filing the annuity or renewal fee, then it will got abandoned. Sometimes it's a withdrawn. Any question? Okay, might be distant. Sometimes it's a lapsed, sometimes it's expired. Obviously, expired means it's a completing. It revoked. If everyone means anyone has unmuted, please mute. Yeah. So if you are working on any technical part or commercialization part, sometimes one invention or one product is having 2 3 invention. One invention is done by you, but that other product part is invented by someone else, and you may need to wait to be that patent need to be dead. So once dead, you can go further with the new invention and that same product in the market. So lapsed is the one thing people check, because if it is lapsed, that means applicant didn't pay the fees, but within 6 months to 18 months, there is very different rule in different countries. They can revive also. So if that patent is lapsed, and then you need to wait few months to check whether that patent will get revived or not, then only you launch your product. So there are certain criterias which need to be work on that. So these are the things.
Ma'am,
Now,
here a small doubt, ma'am. So
yes.
here, is there any heredity or inheritance in place in when there is a death case?
In death case, basically anyone else, there are different rule in death case, but death about applicant you are saying, or death of patent application?
Death of the person who applied for it.
Person. Okay.
Yeah.
So as per the country's laws, there are different laws in the death case. Like generally, it goes to their hair, or a lot, different rules are there. But as per the patent search or patent document, if they are, like, for example, inventor dead and they didn't, that applicant is no more, but he didn't, obviously he is no more, so he will not go for the patent renewal. If it is not, they are not doing the patent, they are not renewing the patent, he is not renewing the patent, it will get automatically abandoned. If someone is going to renew, he has to give all the documents ki how he can maintain. So basically, in general, it's abandoned in the case of, if individual. If it is companies, then it works. Lot of things are there. We need to go to the laws of that
Yeah.
country.
Okay. Yeah. Yeah. It's a single applicant or a co-applicant will vary.
Yeah, right. Yeah.
Okay. Got it.
Sometime, if in his life he has given license to someone or assigned to someone, so those things also need to check over that. But as per the government, if you are not renewing, if you're not paying the fees every year, then it's get abandoned. So now the main part of this session, where to perform. So we have learned why to perform and parts of the patent document. So while performing the searches, that will help you. So there are a lot of database, like every country, they are publishing the data of, obviously, globally, each and every country has to publish their patent applications. So individually also you can search every country's wise, like in Indian, it's an INPAS, we called it in short, Indian Patent Advanced. And there are Japanese and different offices. There's a global patent search, most popular Google and WIPO search. They cover many countries. WIPO, I believe it covers more than 80 countries. Google also cover 80 around. So people in general, they do a lot of Google searches. So Google patent is also very common for all the students and many people. And then paid database. Many options in market. I'm dealing with Orbit, so I'll show few things about the Orbit here. So it's Indian patent system. If you go to the INPAS, there is an option whether you are which type of publication you are searching. If it is published, if it is granted, you have to write the title, or maybe applicant number, publication number, whatever information you have, you can fill it and apply the logical operators and get the result set in Indian Patent Office. This is the USPTO when you do the searches. This is the page where it will ask, you can write patent number, name or assignee number, those things, and then you can do the searches further. This is a SpaceNet, European Patent Office. Similar search, advanced search is there, classification search are there. When you scroll in these things, you will find many options, and you can write your word, like technical word, if you don't know the applicant number and all, and you can do the searches. The result will come like this. You can scroll it. If you click on the title, you will get more details, abstract, claim, every details you will get there. You can download the claims, you can download the description further for your study, and you can check. Same way the Google search, you can search in patent, and even you can include the non-patent literature. Everyone do things, you can find out, and you can read the things. everywhere there is option for downloading the PDF. In general, if you download the PDF, you will get in that particular parent, the main country's PDF. This is WIPO, patent scope. It's also provide a lot of information on that. The similar way in most of the cases where you can apply, there is a question mark. You can check what exactly written. If you don't understand what does it mean, then you can check and apply those things and do the searches further in WIPO. WIPO is having also very good collections, better than Google patent. SpaceNet and WIPO is recommended for most of the students to do the searches to get the good result set. Now we will talk about the limitations of free database. So data limitations, even it covers 80, 90 countries, but full text is less. If you talk about the full text, that means full description. So most of the time you will find only title abstract. And if you want to get drawings, if you want to get claim, description to understand that technology, many times it's lacking. So data is limited. Data quality, the question mark in a free database. The reason is they are not liable, or they are not answerable to the public to update it fast or as per their rule. So there is a sometime gap in the data, and sometime translations issues are also there. Coverage, for example, if India, we are covering from 1912, and searchable full text we are covering from, I think, 2005. So maybe in some of the free database you may get the data of Indian patent application from 2010, 2012, like that. So there is a gap. Even if they are saying they are covering China, they are covering India, but maybe they are not covering each and everything. So there may be some coverage gap. Searches is very tedious job. When you do the free database search, limitations are there. When you search, when you perform, it's a tricky to search to get the relevant results. Less options are given there. Further reviewing is very, very difficult in free database. Like when you go through you got lakhs of result, but those are not all are not relevant for you. You cannot go through even all 100,000 results. So how will you find the top 10? Then you have to work out. So reviewing and finding out the relevant patent is time taking in most of the free databases. Legal status is not maintained properly in free databases. It may be expired, but it's showing alive. So that's hampered your decision many times. So if you're taking your decision, you have to rely on some firm or the paid database. Translation quality, obviously, if paid, they are why they are asking for the money, because they are doing the extra effort. They are downloading the patent and translating it. Either they are manually or machine translation, AI translation, but translating and giving you the data in English so you can read it. So translation quality is the issue in Google patent most of the cases. Saving data is another issue. When you download, if you want to download the data, 100 data you got, 100 results you want to download and further read, you have to download one by one. That's another challenge. 100 patents downloading one by one is a big challenge, time consuming. So saving data is a big issue in the free database. You cannot create the alert in the paid database. You can create the alert. As I said, there is a gap of 18 months. And if you want to be ahead in the market, if you want to keep watch on each and every publication related to that technology, people keep alert in big companies. So any technology related, any publication, new publication related to that technology, they discuss, they get that publication, they discuss within the team, if their competitors, what they are doing, whether they are ahead of us, or what's going on in market. So a lot of things you can do by getting the new technology there. And then further analysis. Obviously, analysis will not be there, because if you are doing the landscape, you need to play with 100,000 results. And for those, you need to download the data, you need to play with the data and present it to your management management or higher authority for your purpose, whatever you are looking for. So now this is the orbit intelligence. It's a paid data where it's a basically cloud-based, and from anywhere anyone can access, but one person at a time can log in. It's basically assigned to the email ID, and you can create your password and access it further. So being a paid database, since we are into the market since last 45 years, we provide one of the best data, quality data, because we try to be most up to date. We cure the data, we normalize the data, especially for the Asian countries like China, Japan, Korea. In China, in many cases, you will find the result in English, but maybe that will be like sometime assignee is different because the translation is not done properly. So those things are there. Obviously, being a database provider, we work on, so in that we provide multiple features. In a free database, if you have 10 features to search, you will get more than 100 features to search in a paid database. So you can like restrict your searches. Like for example, if you're searching in uh, anything like watch, nowadays people are working on wristwatch, a lot of technology that can monitor your heartbeat, that can monitor, maybe these are the very old fashioned, but in new technology people are working on the devices where it can be monitored more things, measure more body things. So for those things, you need to restrict your queries, classification. You need to find out the patent, look, because while drafting, even people play with the different words, different synonyms. So you need to work on that and get the result set. How you can do the search? That's the last part here. So you have database, either it's a free or paid database. For example, you have the access of paid database. So how will you do the searches? You got the login, you did it. How will you start? So first of all, you have to define the scope of invention. What exactly your invention or your colleague's invention or whoever has given you the invention disclosure, what is the scope of that invention? What are the features that inventor is claiming? Feature 1, feature 2, feature 3. And then you have to find out the keyword, like from features, as I said, a wristwatch or devices which is portable. So portable is the one feature. Maybe monitoring the BP is a one feature. So if you're saying portable, it may be written in different synonyms. So you have to create the keyword. After defining the scope, identifying the key features, you have to work on keyword. You have to, for feature 1, these are the 5 keywords. For feature 2, these are the 6 keywords. So you have to write down first on your notebook or any notebook on computer or hard notebook. And then by doing the normal Google search or WIPO search or anything, you extract the classification. Okay, what all the classification, because classification, your term might be very common. Portable is very common. It can be applied in many technology, many areas. But if I talking about the some devices which is can be carried by your hand, then the classification, proper classification should be there. If you are working in medical areas, then proper classification should be there. So then you are restricting, you will not get lot of result, unwanted result, you will restrict it. So you have to work on keyword, then you have to extract the best classification, check the definition of classification, which all the most suitable for your technology, combine it, frame it, we called it frame search string. So you have to frame it properly using the operator or not, and operator. There are a lot of different operator given by the paid database. We use sometime operators like D, W. If you filling a process of this technology, so process and technology, in between 2 words are there of this, so there should be gap of 2D. So you have to apply those operators to find out the best result. Once you get the result, you get the relevant hit, you got, for example, you got 10,000 results. All 10,000 results, being a person, you cannot go. It's not possible to go through all 10,000 results. So how will you find out the most relevant patents? You have to do the citation. Citation is very similar technology it gives. And similarity search, few database provide the similarity search on the basis of classification and other criterias. So you do the citation. If you do the citation, you will find the very relevant technology. So maybe 10,000 results will increase to 12,000, or maybe it will decrease further, but it will be much more relevant to your technology. Then you can further refine it. If you're feeling, this is the very number of results, it is very vague, I need to work on that, then you add few more technical term, you add more classification, so you can refine it. Either you can extend the result set, or you can narrow down the result set. If you're narrowing down, you have to add more technical word, more classification you have to add to narrow down. And if you're extending it, then you have to maybe remove some technical word, you have to broaden your technical concept, then you can broaden it. If you're doing the citation search, you maybe extend it further. So those are strategy you have to follow to get the most relevant 100 or 150 patent results, and then you download it, save it, and you can compare the claim, you can check the drawings, which one is similar. So those things, there is a different strategy for different kind of searches. If you're doing the novelty searches, your strategy will be different. You're just defining the scope, adding the classification. Till date you are checking what all the published, you are good with the result. If your strategy is FTO, then you have to restrict with countries. Like FTO, it cannot be done the globally. People do wherever they want to do the commercialization or business. For example, you are doing in 5 countries, restrict to 5 countries data only, and do the FTO. Check the dead patent. If same patent is already dead, you can go ahead for the commercialization. So different strategies are there for different searches. So these are the steps by wise you can grow, you can find out, and you can do the best searches. So this is the end of my presentation. Thank you all. I'll go ahead with your questions. So let me know if you have any questions. I think 5-10 minutes left, I believe.
Yeah, Kavita.
Yes, sir.
I don't know whether time permits you or not. Can you just give one example of how to make a search? Take some invention title, and whatever you have taught us, the theory, is it possible to quickly take some example of, say, for example, your any product or any process? Say, for example, I wanted to know about a camera in a mobile phone. I have invented something like that. I wanted to know, whether any prior art exists for that, whether my invention is novel or not. How do I know my invention is novel?
Okay, so camera and
A mobile phone.
okay, so if we write mobile, maybe many synonyms are there.
Or
Yeah,
else, the specific to yesterday is one of the our participant has asked about basmati rice has a patent in other country or not. So yesterday I
that's
tried
a
it.
plant protection basically.
Mm-hmm.
Uh, so only with basmati rice, searching in patent document is not the good idea, because that
Mm-hmm.
comes under the plant protection.
That requires a different database.
Yeah, and it's a very old story where means there was when we started the patent and all.
Okay.
Take some recent example by which everyone can appreciate, the components of a patent search. Basically, that's what my interest. Because the topic is patent search. Say, for example, you have got some brilliant idea. So before undertaking a research or after research is over, so how do you check whether your idea is novel or not? And using any of the tools available, either free tools or paid tools like yours.
Yeah. So, for example, sir has told camera and mobile. So, if you see here, can you see my screen, sir?
Yes, yes.
Yeah. So camera is the one word. In the database, we are suggesting the synonyms as well. So if you click on the plus icon, it will give you the like image captured, all these things. Maybe we don't
What
want to
what
select all these
what
things.
database you are using? That also, if you can mention, probably the participants get.
Okay, I'm using Orbit database
Yeah, yeah,
currently, the paid database.
yeah.
If you go for the advanced search, a lot of options are there. In the search term, you need to add your queries and you need to select the field. So when you select the field, you'll understand, as I was talking about the parts of patent document. So maybe I'm not interested in object of invention, or maybe I'm not interested in independent claim, but or maybe I'm interested in independent claim. So I can select all these things accordingly, or I can add more words. So anything in that, anyone wants to add in camera and mobile? Any other word? Because it's very old, maybe we can, yeah. Anyone can think?
Something like the what we call graphene as a material in the cameras. Specifically, I would like to know. Or I don't know. What are the camera materials?
Yeah, let's go ahead. So you can do the searches. So there are a lot of options, like search term is there, classification there. You can do the classification. If you go ahead, like assignee name is there. You can search by assignee name. You can search by inventor name. You can search in country. For example, I'm just looking in India. I just write India and it will give the things. You can restrict by date. Till today, maybe 5 years back, till only the between 5 years. So those things can be given, and click on the search. So same thing we will do in Google Patent.
This is a free database. All of you should
Yeah,
participate.
Google Patent is a free database, and here I can search camera and mobile, simple one, and then you search. If you see the result set, there is a 100,000 results are there only by writing camera and mobile. In paid database, graphene will not work here. Let's search.
It's a wide angle lens
Yeah.
or a telescopic lens kind of. With a wide angle lens.
Yeah, so we got only 3,154. So you may see why is the difference. First of all, there is a only camera and mobile I added. I didn't give the option where to search. Okay. And free database give all the family member. If it is published in 10 countries, it will give all the 10 different publications. But in paid database, it will combine the family. If you click on any further document, for example, if I click on this, if you see there, how many publications are there? PCT, India, Europe, Korea, and US. So all these publications will appear this much time in Google Patent. That's the difference basically. If I go to the result set, there's a different way of seeing the result. Like it's giving the drawings. Maybe I can hide the drawings. I can only see the portable titles and all. It gives the filter. Like if you see here, out of 3,000, 2,960 is alive. Only 194 is dead. If you might have heard about the standard, like there is a basically in telecom industry, like 3G, 5G, 4G standards are there. So if standards are adding these features, this patent, they are adding, we add here. So only 10 patent, which is a standard, means which quoted by the different standard publications. So it means out of 3,000, this 10 patent is very good. So maybe I can select it. I can share with my colleague by email. I can download the PDF, or I can do the further searches. maybe I can ask system to do further the cited patent. So maybe I can do citing in cited patent. So you have 10 only result. When you go for the citation, it will give you further more result based on that patent, 10 patent. These things you cannot do in the free database. You just go through, click here. But obviously, if there is no option of paid database, you have to rely on the free database, and you can get these details further, and you can download there.
Great.
Yeah.
You got
So if you see, out of 10, we got 1600 approx result, and those 1600 is talking about the same, almost same technology. What I selected 10 result, and in this 1600 result, 419 is a standard one. We can check whether is any licensing done in US. Basically, we provide the license information of US because other country data is not available. So these three document is already licensed in US. If any patent document is licensed, that means that patent document, that invention is crucial. So instead of going through the any other result set, you need to go through these three result set only to make sure ki what you are working and what they are talking about. So am I clear, sir?
Yeah, very good.
Yes.
So that is what the point all the participants should understand is that there are free databases, there are paid databases. If you want more precise, more analytics, one has to obviously go for a paid databases like Orbit. If you want only a broader understanding, and if you have time to do analysis and all on your own, perhaps as a first cut, the free databases are okay. And you've also seen how to make the churches, it's very, very useful for all the research scholars and the students who wanted to do research. These tools are very handy, and one can do research even before starting your PhD. There is no point in reinventing the wheel. If someone has already done the same work, and what is the use? And you may not get your PhD granted, you may not be able to publish your results, you may not be able to get a patent on your results. So always better to do the novelty search before starting your PhD work. And the tools are nowadays are very, very cost-effective tools are available nowadays. During our time, if you wanted to do this kind of a search, either literature or patents, it used to be a nightmare for us, even to do even a chemical abstracting. To do that, huge volumes of books. We used to sit, read, and identify. What are all the relevant papers published? We used to have the cards. We used to note down all those things. But nowadays, after the emergence of internet, everything on your fingertips. Only thing is you should have the mind to think what do you want, and is available. Databases like Orbit, there are many databases, commercial databases are available. Of course, most of them covers the 90% of the features are common in most of these databases. Maybe 10-15% variation. That is what their customer differentiation and innovation content in that. That is how they are able to market, survive in the world. So I'm very, very thankful to Kavita Poddar for accepting our invitation, and I consider her as one of the very passionate IP professional in the country. And thank you, Kavita, for accepting our invitation in a very short notice. I know how busy you are in your company, being a senior executive as a director of the company. We're all very grateful to you and look forward for your continued support to propagate, to promote IP culture in our country, which is very much we are lacking. And I hope our students also asked some of the relevant questions. I do have one more doubt before I think exit, and you can answer others' questions. See, you said backward and forward citations. So backward citations means what we cite in our patent, na?
Yes. Yeah. What Done before me, before.
Before me. That is nothing but a prior art, basically.
Yes, prior art.
Prior art. So forward citations means overall others are quoting our patent.
Yes,
They works.
either supporting or after me they have filed.
So how that it helps you to assess the power of your patent, these two, backward and forward. Just can you
Yeah, so
get some example?
I was presenting one day in IIT Madras, and they have come across one invention out of so many invention, which having lot of citation, forward citation by Qualcomm. So they come to know that this invention is their one of the breakthrough invention, and Qualcomm has cited 15 times that patent. So Qualcomm has taken the base of that invention and then filed a lot of enhancement, increasement in the technology. So they approached the Qualcomm further and they collaborated for that technology. So if your patent is having the forward citation, that really gives value to your patent. And if it is backward citation is also much more, then this also giving the broaden aspect of, because nowadays it's a interdisciplinary, lot of technology come across nowadays. It's not the one technology. If you're in medical technology, you are also working in mechanical technology, mechanical device of the medical field, right? In mechanical device there is a sensor, there is a semiconductor, lot of things are there. So if you're coming across with new technology and citing lot of backward citation, that generality of that particular patent value is highest be considered.
Thank you. Thank you. Nandya, please take over and help our participants to get their doubts clarified.
Yeah, there's a few questions like presentation sharing. Yes, I will do. There's a one questions qualification for patent searcher and researcher. Basically, it's a technical just a qualification. If you are BSc, MSc, BTech, MTech, PhD, anything, you can become a patent searcher. But for being a patent search, you should have the understanding of patent. You need to go through the WIPO. There's a lot of courses are there, D001, D002, like that. Lot of courses are there. And patent searching is basically a skill. It's an art. So if you start with today, maybe 2-3 years with the experience, if you work in some companies, if they will teach you, slowly you will develop that skill, and then you will become the patent searcher. So it cannot be teach in classroom in 1 day or 2 day. It's a skill which developed slowly by doing patent searches day by day. If you take any technology description, you search in free database, find out the best patent. So this is a continuous process in developing the skill, because for patent searcher you have to complete your workforce like task in 8 hours, 12 hours. There's a stipulated time. So within that time, you have to identify the most relevant, most prior art. So using the database, your skill also matters a lot.
But generally, in your own domain, you need to have a thorough understanding what is happening in that field.
Own technology.
That is important. And as Kavita says, there are a lot of tools are available nowadays. So you need to practice them, get the skills. And there are also courses like what we are offering. There are also many people are organizing such kind of a training programs and patent searches, So you should attend such kind of courses and start your career, join in some law firm or some patent firm where their major job is, 50% of the job is only patent searches and giving pre-art patentability search reports. That is how you acquire the skills, and there is no dearth of jobs in this field, Every discipline students can get jobs in IP area, which is growing exponentially in our country because the government of India has been giving a lot of thrust to promote IP in our country. And just the last date over on August 7th, government of India is also recruiting 550 patent examiners. The basic qualification is degree in engineering, science, and that is, I think, basically these are the two. For science and engineering people, patenting offers enormous opportunities, including a patent agent examination. Government of India also conducts these exams once I think twice in a year. And if you prepare properly, according to the syllabus, you can easily crack that patent agent exam. Then you can practice yourself as a patent agent, help the innovators or inventors of academic institutions, or you can start your own company or join somewhere else, in corporates, every corporate sector company has got a IP cell now, and every government department has a IP cell, every university has a IP cell. So jobs are phenomenal. The only thing is you need to acquire the right skills, as Kavita said. Any other questions, please?
Yeah, so there is a questions about licensing patent to the third party. For licensing, first of all, you need to do a lot of work to make sure that there is a value while negotiating. To find out the third party, you have to find out the collaborative partner or potential partner which can take your patent, which working in that direction. As I said in IIT Madras case, they come across they are filing a lot of forward citation and they collaborated with them. So same way, if you have developed anything related to automobile, for example two wheeler, that any battery system which life is longer, then you need to find out the companies who is working in that particular technology, either using the patent database or Google search or anything else. Then you need to present them, you need to approach them, present them, and then only if they are agreed with your, they liked your invention, then you can license it. Licensing, there are few like sir has worked in NRDC, so NRDC helps all the inventors, startup to license their product. They are primarily focused on the technology transfer, licensing their technology. So NRDC is the government, Indian government organization.
Yes.
Yeah.
You
Another
can.
question is book. There is a lot of book. I don't remember any name, but the best way to learn about the IPR is WIPO Academy. You go through WIPO Academy. There is a free courses, lot of free courses. Their explanation is really nice. Even I go through sometime. So you go through WIPO academic section, and you will find lot of things, lot of materials there, and you keep learning one by one. So you will get the certificate also.
They are very well valuable certificates. Even while applying for jobs, also those certificates will help you a lot.
Yeah.
Yeah. Next, any other question?
No, sir.
If there are no other questions, we have 1 more minute. The next speaker has already joined. So 4 o'clock, I think his session starts. Any other questions? 1 more minute. Every minute is valuable for you.
So I believe I have done the good job and I explained the things in a better way. So everyone understood.
Yeah.
What is that academy, ma'am? Vico Academy.
Yeah. WIPO Academy, right? World Intellectual Property Organization. Great. Lot of appreciations for your talk.
Thank you.
Virtually.
Sir will let you know the cost. There is a different things cost involved. First filing, I think it's very cost.
1,500 rupees, government and students, academic institutions,
Yeah, it's,
natural persons.
I think 1,000 or something. I don't remember currently.
1,600, 1,600.
Yeah, 1,600. Currently 1,600, and then filing the examination request, and then other things comes. So till grant, maybe drafting is also costly. So at least 50 to 1 lakh, 50,000 to 1 lakh, depending on the things.
That's true.
Yeah. Okay, so thank you so much for attending the session, being attentive, and I hope you liked. Chalo, see you. Bye.
Right. Thank you, Kavita ji. Have a
Thank
good
you, sir, for inviting. Thank you so much.
Thank you very
Bye-bye.
much, ma'am. Thank you. Bye.
Thank you, ma'am.
You want any 5 minutes break or you would like to continue?
Sir, just a tea break for 5 minutes.
5 minutes. Okay.
Yeah. Thanks.
Now, but this 4-5 we will meet.
Sure.
Meanwhile, the attendance, I think, Dr. Ananjay, you are posting the attendance sheet. You already posted. Ram Nishant, You asked a question, good question, how much it costs for patenting. As Kavita said, if you are from an academic institute, the government fees is very less. But the most of the costs involved while drafting, you have to avail the services of a patent agents or a patent attorney or a patent law firm. They charge quite a bit, depending upon their reputation in the market. Like if you go to a famous lawyer, he will charge 1 lakh rupee per 1 minute of his time. If you go to a normal lawyer, he may charge for doing the same job maybe 10,000 also. All depends on the reputation, but the agents may charge rupees 30,000 to even 3 lakhs, depending upon the complexity, depending upon the firm's reputation. So we have a tie-up with the Novel Patent Services in Visakhapatnam. We discovered the price by tendering the services. This emerged as one of the service provided to us at a very competitive rates compared to all the big firms, and we are happy with their quality of their service. They are our patent agents for attorneys for filing all the patents of Andhra University. So, Mr. Murali, who is the managing partner and MD of the company, Novel Patent Services Limited, he is going to deliver his talk on reading patent documents and drafting the claims. All the patent protection, whatever applications we are filing for a protection, is lying in the claims. Claims means what are the benefits of your invention and what experimental conditions you are able to arrive those benefits. What are all the raw materials? What are all the process conditions? All these things are part of those claims. If somebody copies, replicate the same claims of your patent, then you are having a right to sue on them, the people who copied your knowledge. If they have a knowledge beyond the scope what you have described in your claims, you don't have any right. You have right only for the knowledge what you have disclosed to the government, seeking protection, So that is the basic tenets of the IP protection. You all should know. Whatever you are disclosing only will be protected. If you don't disclose to the government, you will not get protection for that non-disclosed material or invention, So that is why at the time of filing patent, you should disclose as much as possible. We all say, when you go to the doctor and when you go to the lawyer, you should tell all your problems. You should not keep anything secret. You will be at loss. The same way here also, in patent filing also, you should disclose all the knowledge what you have acquired, what you have invented, in your patent application, so that that knowledge will be protected by the patent agent who drafts our patent application and gets protection from the government on our behalf. This is very, very important. Murali, did you join? Murali. Mr. Murali? Yeah. I think he joined. Let us all welcome Mr. Murali, who is the managing partner at Novel Patent Services Private Limited. And also, like all of us, he did his engineering, and he could see a lot of opportunities in the patenting services. It was emerging. I think about 10 years ago, he started his venture, and now I would say he's one of the leading services provider in the entire state of Andhra Pradesh. Now they are expanding their operations. They opening their office in US. So that is a kind of business opportunities available in this area. What is important is that you should have that kind of a passion, commitment, risk-taking abilities. Their couple, both of them are qualified engineers, and they join hands together to establish this novel patent services, and they have been doing extremely well, and their presence is felt across Andhra Pradesh. I don't think any university or any education institute or whoever is doing research, in the state of Andhra Pradesh, they all get their services. I don't think anyone has left, to utilize their services. So become so popular because of their attitude towards their clients, customers, and their passion and their knowledge in that area and their networking abilities with the stakeholders. So these are some of the things I've seen in them, and we have been associated with them, at least as a part of my CMD of NRDC. That is the time when we got introduced to each other. So almost for the last 10, 11 we've been working very closely and observing their growth and their aspirations. They're doing very well. And thank you, Murali, for accepting our invitation and sharing your experiences to educate all of. Again, students, I request all of you to interact with him. My slogan is that 30% only you will learn from listening to the regular talk. The remaining 70% and clarity comes only by way of interacting, by raising questions. So please make use of this opportunity. There are very, very busy people. Even I don't get time of this, and whenever I want, I have to wait for their call. I give a ring, and they, at their convenient time, they will call me back. Such is the amount of time. No, actually they don't have time for doing other things except for their own business. So we, based on our relationship with them, they've accepted our invitation, and please make use of this time very efficiently and very effectively. I invite Murali, and Murali, welcome to our session, and floor is yours.
Thank you, sir. Thank you very much, sir. Good evening, everyone. As Sir told, my name is Murali, and I'm the Director of Novel Patent Services. We started our company in 2010, and our office is at Gambiram, and we have more than 75 plus members working with our company in different teams. Like it can be from drafting, analytics, drawings, and even prosecution support as well. So we do A to Z support for all kinds of intellectual property rights related services. So today, as per my topic, I would be just giving you an introduction about the structure of a patent and different parts or different sections of a patent, and even a slight introduction about drafting of claims, so that whenever we draft and give you an application, you should understand why did we do this, and in what section of the patent application you will have what kind of information, so that you can better understand the technology, and you can even suggest us with respect to the technology, where do we need to improve. Maybe with respect to the style of presenting the draft, we are good at it. We still improve it. We still try to improve on it. But at the same time, what we need from you is, with respect to technology, if we miss out something which is important, and if we did not cover in our patent application drafting, if you can suggest us, it will be helpful for us during prosecution. So first I will try to share my screen. Can you see my screen, sir?
Yes, yes.
Yeah. So, as per the topic, today my topic will be on two aspects of the patent. The first thing is understanding the specification or understanding the structure of patent and patent claim drafting. So the basic thing is, as Sir said earlier, whatever, suppose if we invent something, like there will be two important phases in any innovation. Of course, we can divide it into n number of parts. Like maybe it can be broadly divided into three. The first part will be like your conceptualization or your unique way of thinking or your unique way of solving a problem. That is the very first and important part of this IPR. Once you get out, come out with a very good, unique solution to a problem, it is always advised to protect your patent application with the your innovation with the help of a patent application. And the third part will be how do you commercialize your invention. So we can divide an innovation in majorly with respect to IP into majorly into three phases. First thing is how do you conceptualize your invention. Can you protect it with a patent, or can you protect it with a copyright? Can you protect it with a design? You need to decide on that. Once you decide that you are supposed to file or protect with a patent, you can first draft the patent application in a proper manner as per the rules of the patent office wherever you file. And then after getting a grant or before the grant itself, how do we commercialize that invention is an important, these are the three major things which we need to take care of. So drafting is very key and important part of IP. Unless and until we take care of complete invention, where most of the times, sometimes we might get a grant of a patent, but most of the times while we are commercializing that application, it will be of no use because of no proper use of proper terminology, or while drafting the application we did not draft it in a proper manner, or we did not cover the entire invention, or we did not take care how exactly our competitors would work on our invention without infringing our application. So while drafting an application, we need to take care of all these aspects and draft the application. And there are many important sections in the patent law, especially section 10, which says that you got to completely disclose your application or your invention completely to the public. If you don't disclose it in a proper manner, sometimes it will be used in post grant oppositions or pre grant oppositions, or even during the prosecution. It might lead to a situation where you will lose your right on your invention. So as per section 10 of Patent Act, it says that you got to disclose completely the whatever your invention is there, your unique solution is there, should be completely disclosed to the public. And one more thing is, we need to remember, I think in your earlier classes you might have heard many times that patent or IP right is a quid pro quo system, where you got to disclose your public. In return, government will give you a right on your invention, or an exclusive right on your invention for a period of 20 years. Only if you disclose your invention completely to the public, only then government will give you an exclusive right for a period of 20 years. Otherwise, if you don't disclose it completely, undisclosed part will not have, you will not have right on undisclosed part. So while disclosing a patent application, an invention in the form of patent application, we need to disclose to the maximum possible extent or in the right manner, where how the patent office has defined it. So in any patent application, whenever we file a patent application, we file with patent offices like Indian Patent Office or US Patent Office or WIPO, intellectual, we call it as PCT application. There will be a cover page or first page or front page. It would look like this. If you can see the screen, if it is for USPTO, this will be the format, and for IPO, this will be the format, and WIPO, the first page will be like this. Where in USPTO, the general, if you download the original document of USPTO, which is published after grant, will be having this information, where you will have a standard mandatory information which needs to be filed by the applicant, and these will be the references and abstract of it. Sometimes need not be every time, you need not have all these references, but at least some of the references which we need to suppose to quote will be there in the patent office, and this is abstract part of it. If you see here, you can find title of the application, inventors, whoever has contributed to the conceptualization of your idea will be called as inventor, and assignee, who is an assignee? Assignee is the owner of the application. So sometimes the same inventor can be an applicant or an assignee. He is called as an assignee or an applicant. So who will be the owner is the applicant, or an assignee will be the owner. Inventors will be the persons who will be contributing to the invention, but they are not the owners of it. Sometimes what will happen, they will not have a separate assignee or an applicant, and those inventors themselves will be assignees or applicants. Then those inventors will be the owners of your application. So, and you would find application number, dates, and all the bibliographic information. We call this such information as bibliographic information, which are mandatory, the patent number, all this date of application, all these things, we call them as bibliographic information. And there will be technical part of it, and we can see even that. And when it comes to Indian Patent Office, we call IPO, Indian Patent Office. When they publish in their Indian Patent Journal after grant, this will be the structure. As usual, in US patent, you would find this would be the format where international classification, US classification, everything will be there. Here, the format will be slightly different, but more or less the information what they provide will be in this manner. And this is abstract. And when we file an WIPO application, this will be an WIPO application where the same what you find over these two, I hope you know what is WIPO. When we want to file our invention in different countries, there are two different ways. How do we file our patent application? One is conventional way of filing, and the other one is PCT way of filing. We call WIPO or PCT way of filing. And in this, you have only application, you will not have any grant, and the same application what we have filed will be in this format. Like you have bibliographic information, abstract, and you would even have important diagram which would depict your invention will also be there with abstract in this PCT application. So before going in detail about these structures, let me understand, do you know what is how do we like suppose for example, just a minute, like when we file a patent application in India, so or in PCT application, does anyone know what would be the like how do I protect, would I get patent right in all the countries or only in India?
Only in India, sir.
Okay, so how do I protect my patent application in other countries?
Through PCT?
Yeah.
Okay, so there are two ways of applying to the different countries. Like one is conventional way of filing the patent application, and the other one is PCT way of filing the application. PCT is Patent Cooperation Treaty. Convention is like whatever treaties we have between different countries, they would follow as per those treaties and they would file. In as per conventional way of filing patent application, there is a time limit of 12 months. Within 12 months from the date of filing of your application in India, we need to file in all those countries wherever you file wherever you want your application to be, or wherever you want your exclusive right to be reserved. Like for example, you wanted to file in US, you wanted to file in UK, and you wanted to file in Australia. And if you follow a conventional way of filing, you need to file all those applications in those respective countries within 12 months from the date of priority or from the date of application of your application. So within 12 months. So sometimes what would happen, our application or our invention might have many like very good impact on the society, and we might have a market in almost all in every country. So sometimes we need to do a market due diligence and decide where to file our application, because in India, cost of filing a patent application is relatively very less, except our fees, our service fees. But in US or in any other countries, even the government fees what we need to pay are very high. So we cannot just go away and file wherever you want. So we need to spend money, we need to spend time, we need to find a agent there, and we need to file those applications there. And if we file there, we would spend money only if there is a market there, right? So sometimes what would happen, we after inventing, in order to protect our priority, what we would do immediately, the moment we get conceptualize a new idea, we would try to file a patent application in India, and then within 12 months from then, we need to file our application wherever we feel that we have market. So sometimes doing due diligence, arranging money to file in all those countries will be difficult to do within those 12 months. So there is an alternative system of filing a patent application, that is PCT, where you can take minimum of 30 months. Like you got to file PCT application within 12 months. You got to do that. Even here also you need to file a PCT application within 12 months only from the date of priority or date of application of your invention. Within 12 months you can file. But from the date of filing, you will have 30 months time to do your due diligence, to arrange your money, and to decide where to file, and to find out a patent attorney who can help you in prosecuting your application in those countries, and everything. You can do whatever you want in those 30 months. So naturally, if you need some time, and when you're generally what we do is, when we try to file in more than 5 countries or 4 countries, we generally suggest people to go with PCT way of filing, Patent Cooperation Treaty. So in PCT cooperation, using that treaty, we can file a PCT application where we would reserve in more than 145 countries, like with just single application and with just single tick mark, we can reserve our priority date in all those 145 countries, whichever has signed the GATT agreement would be the part of that system. So we can reserve the priority date. But only difference is, there is an international patent application, but there is no international patent grant. That we need to remind. So from the date of filing of your first application in India, from there within 30 months, we need to decide where to enter, where in whatever country you want to file, and you need to go. So that is the reason why we need to understand the different structures of the patents.
Sir.
Yes.
Murli garu, there is just small correction I want to make myself.
Yes.
So within 12 months, we need to apply in India as well as another country, and there is a time period for 30 months to make a payment. Am I correct?
No, sir. Actually, whenever we want to file our application in different other countries, there are 2 ways of filing, sir.
Okay.
One method of filing is conventional method of application.
Yeah, that I understood.
In those, in that system also, suppose let us say you want to file in US, you need to file before 12 months, and you need to pay the respective government fees of US within those 12 months, or while filing the application itself, you need to pay the fees.
In convention.
That is convention. For PCT, what will happen? We will pay only the PCT fees within those 12 months. The PCT fees will be 80% less for an Indian applicant, especially for an individual. If you file 80% less, so we would pay only the PCT fees, and we would reserve our time for a period of 30 days. So when entering into each country after 30 months or just before 30 months, we need to pay again fees for each and every country wherever we are entering.
Murali, I think you wanted to know, I think you need to clarify.
Yes, sir.
You see, first you have to file application in India before filing application in other countries.
Yes, sir.
That you should remember. And within 12 months of filing your application in India, you need to file either your PCT or convention route. That is a point.
Yes, sir.
From the date of filing your application in India, within 12 months, you should file your either convention route application in foreign country or through PCT application in a foreign country. The 12 months is, in both the cases, it is same. If you want to file, if you want to seek protection in foreign countries. That is a point what Murali has mentioned. Am I right, Murali?
Yes, sir.
Yeah.
Yes, sir. But PCT will have plus 18 months. Plus 18 months time. So in order to buy 18 months, we will be filing 12 months. This PCT route, sir.
Clear now.
Okay, sir.
Thanks.
Thank you, sir. So can you see my screen, sir?
No, we are not able to see.
Okay.
Sir, in PCT we'll have 12 months plus 18, or it is in total 30 months?
12 plus 18, madam. Like it is total 30, but within 12 months you got to file your PCT, and from so total will be 30 months.
Even 30 or 31 months. Few countries have.
Most of the countries 30, sir. India and some countries, maybe somewhere around 10 countries will have 31. Europe also have 31 months. So written description followed by the front page is called a patent specification. So naturally in the front page, we call them the information, whatever we see is a bibliographic information, and the information what we see within the patent is called a specification or the technical description of your invention. So if you see the anatomy or the structure of the Indian patent application, you would find title of the invention, field of the invention, background of the invention with regard to the drawbacks associated with the known art or the prior art, object of the invention, statement of the invention, a summary of the invention, and brief description of the accompanying drawings, and detailed description of the invention with reference to drawings or examples, claims, and abstract. These are the parts which we need to write about your invention. Like in any application, we need to write all those sections, and each section will be described in the coming slides. And the second patent, if we see a patent cooperation treaty or PCT application, the major sections will be technical field with respect to the specification, technical field of the invention, background or art or prior art of the invention, disclosure of the invention, brief description of drawings, best model for carrying out the invention, or industrial applicability and claims. And for United States also, this would be the structure, like it would have title of the invention, cross reference to related applications.
So sorry, sir, we can't see your presentation if you are presenting.
I think you could see this slide. Indian patent. And now this slide also, like in patent cooperation, like PCT application would have all these sections: technical field, background, disclosure of invention, brief description of symptoms, best mode or best model for carrying out the invention, industrial applicability, and claims. And when it comes to United States or US patent application, these are the some of the sections. Most of the times, everything is similar, except like you need to mention even the cross references to related applications if there are any. And we need to mention even for Indian patent also, we need to mention even the sequence listing also. Rest of the things, the names might change, but most of the times the structures of the any patent will be almost similar. So let us try to understand in each section what do we write. In title of the invention, we should reflect the main art of the invention, and it should not be more than 15 words. Any title of the invention should not be more than 15 words. It is with India or even with PCT or any country. It should not be. Generally, it is preferred. It is preferred only. Like it is always recommended to go only with 15 words, not more than that. If it is required, it will be considered as a special case, but it doesn't mean that we will not be allowed to file a patent application. But generally, the procedure what we follow is we are supposed to constrain our title to be 15 words. And when it comes to the field of invention, here we need to write in a single word where exactly our invention is trying to talk about, or what are we, in which area our invention will be, and specific thing like on a broader view or a bird view, we should be in a position to tell where exactly the invention is. Suppose, for example, my invention is in solar power system, and especially on a capacitor of the solar power system. So in specific, my invention will be with respect to the capacitor, but when it comes to the field of invention, it is about power consumption sentence. So field of the invention will be like where exactly in which area this invention is all about. And in specific also, like my invention or my research is more on the capacitors what I use, or the power system I use, or the circuit whatever I use. If my invention is more on that, so then I would write even a single sentence stating that in specific my invention is about the circuit system for this solar power. So, and next, it is one of the important section of patent where we would be writing the background of the invention. Generally, how does it start is like we would try to give the basic introduction about the technology, like to which area this belongs to. Suppose, for example, if I am talking.
So
Sir, you are on mute.
you're on mute, sir. Yes.
Still, you are on mute, sir.
Yes. So in background, what we generally write is like a few paras will be like introduction about the technology area where what we are trying to tell, and in the second section of the background of the invention, like we would try to tell what are the closest references what we found in our search, and in what way it is different, but what do they lack. We don't directly compare with our invention, but generally what we do is we would try to narrate what is there in the art till date. That means whatever references we found in our search, and we would try to highlight the important points of that invention, and at the same time what is not there in that invention with respect to our invention. Like, but we will not directly state our inventive point, or we will not directly compare with our invention, but we would tell that some point is lagging in the prior art. So in the middle section of the background of the invention, generally we would try to mention about all the prior arts which are close to our invention, and we would try to highlight what is not there or what problems exist in the prior art. And in the last section of the background, what we generally do is we would try to summarize all the problems whatever we have mentioned in earlier section of the background of the invention, and we would say that there is a need for solving that problem. And generally what will happen in any field, there are a number of problems. We generally don't talk about all the problems, but we would try to talk only the problems which are related to our invention will be mentioned in the background of the invention. So in first section of the background of the invention, we would try to give the introduction about the technology where we are working. And the second section of the patent, we would try to, second section of the background of the invention, we would try to talk about the prior art, what is there till date, and in what way, what problems are there with respect to our invention will be mentioned there, and summary of all the problems and a solution, what is required for as a solution will be stated in the last pair of the background. It is important because unless and until we narrate it in a proper manner, we cannot emphasize the importance of our invention to the examiner or even to the licensee or to the company, whoever is buying it, unless and until we narrate it in a proper manner, whatever background we are trying to talk, unless and until we emphasize it, or the problem, unless and until we highlight the problems what we are trying to resolve, we cannot sell our invention, or we cannot even convince an examiner. So even the background of the invention, though we don't have any right on the background of the invention, but background of the invention would play an important role while filing or while drafting a patent application. Though we try to talk only the prior art, and we will try to summarize all the problems that are existing in the technology with respect to our invention, and we would just say that there is a need for a patent, or there is need for a technology with so and so features, but we don't even disclose anything about our invention there, but still it helps us in convincing the examiner. Next will be the object of the invention, where you need to write what are the advantages you would get with the help of your invention, especially the advantages. Like, object of the current invention is to attain something, to increase the efficiency, to increase or to decrease the temperature at which we are working, or any other advantages. The material what we try to use will be reduced, or the cost of the equipment what we are trying to make will be reduced, or the efficiency will be increased. All those objectives are what objectives we are trying to achieve with our invention will be mentioned in the object of the invention part. In statement of the invention, what we generally do is we straight away give our key inventive problem or key inventive step what we are trying to file with our application will be stated here in the statement of the invention or key invention. Like, when you describe your invention, there will be number of lines, but there will be a single key inventive step. Normally a patent will be given for only a single inventive step. They don't give a patents for more than one single inventive step. When I say single inventive step, suppose for example, if you consider a laptop, there are n number of features in this laptop. For example, brightness is one part where you can work on, even the keyboard is one part where you can work on, or even your camera is one part where you can work on, battery backup, all those things are different features where you can work on. Like, suppose for example, in this scenario where I am trying to file my patent application, my invention is on adjusting my brightness of my laptop automatically with respect to the environment around me based on the thing. So here my key inventive step will be to adjust the brightness of the screen with the help of some sensor or some capacitor or some diode, some electronic part. Using some electronic part, I would try to adjust the intensity of the screen based on my environment. Naturally, we need a sensor to diagnose my environment, brightness of light in my environment. At the same time, and a controller to adjust the intensity of my thing. So naturally, what will be there, using this sensor and controller, I will try to adjust my intensity of my screen. So this would be my statement of invention, like the key inventive step or key inventive point of my patent will be, or my application will be stated here. But when we try to write in other sections of the patent, we generally don't stop writing only about these two things. We generally try to talk about all other peripheral or any other things which are attached or which are related to this particular circuit also. But in statement of the invention, we will directly state only the key inventive point, which is very important with respect to this invention, and this will be stated in statement of invention. In summary of the invention, generally what we do is we need to give a brief synopsis of my complete invention or what I am trying to claim. And especially what we generally do is whatever is written in claims will be written in normal language here in summary of the invention. Normally in claims, what we do is we use a legal terminology, or we try to be very selective with the terminologies what we use, and we try to be very we try to use very small sentences or phrases so that we talk less, but we will try to claim more. If all those steps or all those precautions will be taken while drafting claims. But when we try to draft summary, we will try to narrate the same phrases or the same sentences what we have written in the claims in summary of the invention, but in a more detailed manner, in a more common language, rather than depending on specific terminologies what we generally use in claims part of it. So summary is like the overall view of our invention, need not be the complete specification, but main inventive thing will be described in more number of sentences, rather than in earlier section in statement of invention, we will try to tell only the single key inventive step will be given in statement of invention. But when it comes to summary of the invention, we will try to tell more about my laptop, we will try to tell more about my construction of my laptop, and all the things whatever I will try to claim in claims will be given in normal language in summary of the invention. And next section will be brief description of drawings. Here we don't draw drawings, but we will normally when we try to explain our invention, it is prescribed as per the patent law, or it is a general practice that we will try to explain our invention with the help of a drawing, or single drawing or multiple number of drawings, how many we feel like are important or required to explain completely about my invention. I will try to furnish all those drawings. So here what I try to tell, this is a peripheral view of my invention, or top view of my invention, or sectional view of it, or perspective view of it. We will try to describe what kind of drawing is figure 1, what kind of drawing is figure 2, what kind of drawing is figure 3. Everything will be given in this 7th section. Normally drawings will be given in fresh pages at the end of the after abstract as a separate thing, but we will try to describe what is figure 1, how many figures we have given, and all the figures will be described in this section, 7th section. And when it comes to detailed description of the invention, this is very, very important. Sometimes what would happen while drafting claims, to be very broad and to take care of our invention, to increase the scope of the invention, we will try to write all like more broader terms in claims. and at the same time, there is a rule in the Patent Act, either in USPTO or in any of the patent laws of around the world. What is there is that whatever you write in claim should be supported by your specification. Normally, what we generally do is we would try to support it completely. Our whatever we try to write in claims will be completely supported by your detailed invention disclosure or detailed description of the invention, where we will try to disclose each and every part. Like, for example, how sometimes we will try to, suppose if we feel that narration of prior art is important, we will try to tell even the description of the drawing or the equipment, whatever is there till date, and the new thing what is there, what are the new embodiments which we try to claim here, or compositions what we are trying to do, and the method to achieve it. Suppose, for example, if we are trying to claim a product patent that to a mechanical structure, let us take for an example, if you are trying to claim a mechanical part or mechanical let us say if you are trying to claim a bicycle, here we need to explain the complete construction of the bicycle, and we need to give even like more importantly, like suppose for example my invention is more on brake system of it or the gear system of it. Let us say we know that even there are gear bikes, even there I have invented something or innovated something with respect to the gears. But while writing in detailed invention disclosure, I'll not just try to talk only about the gear system, how exactly it is connected and everything, but I would try to write even overall the bicycle, where the gear system will be there and how exactly it will be connected, when exactly it will be operated, how exactly it will be triggered. Every scenario with respect to this invention will be described in the detailed invention disclosure. And when it comes to chemical compositions, here we need to write composition, how exactly, what are the compositions. Like suppose for example, there is a compound which is made of A plus B, which gives to C, and A is of 40% and B is of 60%, which gives to C. If I say that C is the new compound, I need to say at what temperature I am trying to mix A and B, and at what pressure or what scenarios I am trying to, or am I taking nanomaterial, am I taking any other synthesis material, whatever it is, whatever I am trying to claim, first I need to write about the composition, the method of synthesis of that product compound, how am I trying to get that compound also needs to be mentioned there. And at the same time, I need to furnish, for especially for chemical related patents, I need to furnish, or we need to furnish, especially the experimental studies which support your compound. Like how do you say that C is a compound that exists, or that means it doesn't deteriorate, or you can utilize that. So all the experimental studies, whatever is required to support your compound C, also needs to be written in your detailed invention disclosure. So detailed invention disclosure is one part where if you read the complete detailed invention disclosure, you will try to understand complete technology of your patent, and you will know what is invention, everything. But everything will be there, not just only the inventive part of it, but A to Z of it will be there. At the same time, in detailed invention disclosure, we need to take care that we need to like as a drafter, what we try to do is we try to increase the scope of the application. How do we try to do, how do we try to increase the scope of the application is we will try to write ramifications of it. Like suppose for example, with my gear system, or with, let us say A and B gives to C is my invention here, and this patent is more about the composition, not on process. Or let us say if there are two inventions, like suppose I want a patent, like if my process is a new thing, at the same time even the product is also a new thing. Let us say A plus B gives rise to C is a new thing, and the process of synthesizing C is also new thing. Then it is always advisable to file two separate patent applications, one for composition of it and the other one for specific the method of synthesis also needs to be written here. And if I am trying to claim, or if I am trying to write about A plus B gives to C, sometimes what would happen, though don't consider these examples to be very important. Let us say isotope of A also might give rise to C, and isotope of B might also give helps in synthesis of C, or sometimes ethyl alkyl group of A would also help in synthesizing C, and alkyl group of B would also gives rise to C. All those things, all the derivatives, or all the salts, or all the co-crystals, whatever different forms which would help in getting or synthesizing C, in attaining C, will also be considered while writing the draft. So sometimes, most of the times, inventor would give only A plus B gives rise to C. But as a drafter, I need to take care, how do I broaden it? Generally, what I need to do is, I need to see what are all the derivatives which can also be claimed, or which can also be protected and with my invention. Like suppose, for example, as I said earlier, isomer or isotope or alkyl group or any other thing which is related to this A, or which is related to B, also needs to be mentioned. So all those ramifications, suppose for example A plus B gives at temperature of 30 degrees centigrade or 50 degrees centigrade, I would synthesize C. Most of the times inventor would just give me at 50 degrees centigrade, we would try to synthesize C. But what we generally do is, we first, because we generally do patentability search, there we would try to understand what is there till date in the prior art. Suppose someone is working at 25 degrees centigrade, and we found some other patent to be working at 70 degrees centigrade, then what we generally do is, we would, though inventor might have given me only 50 degrees centigrade, what we generally do is, my prior art is permitting me to write about like from 30 degrees to 60 degrees where someone else is working on it. So from 30 degrees to 59 degrees, I have that range. So I will try to claim even that range. Though my inventor have given me only 50 degrees centigrade, I will try to claim even that. Sometimes it might be absurd, or sometimes it might not give me the effective result, but keeping in view the competitors in mind, and keeping in view to stop others, because it is a negative right, we need to stop others from using our technology. So we generally try to increase the scope of it. At the same time, ramifications, when I say ramifications, this is one kind of ramification, and different derivatives or isotopes, all those things can also be considered as ramifications. And I need to see in what way, if I launch my patent in this manner, in what way competitor would do, or he would make sure that he is not infringing me, but at the same time he can use my technology. If I can stop that, I am protecting my application in a right way, in a right manner, and I can make utilization of my unique thinking. It is not just copying. So what is that? Who he knows that it will be an obvious thing, and he will try to modify your invention. He doesn't want a patent, but he wants to be in market. So most of the times what will happen, once we draft a patent application, if we don't properly take care of your invention, what will happen, your competitors will be looking at your technology, they will try to make minor changes where they don't come under your claims, or they will make sure that they are not infringing your claims, but at the same time they attain the same result what you are trying to get. This is nothing but copying or doing reverse engineering and trying to make sure that they are not infringing you. But so while drafting, it is my responsibility to take care that some competitor doesn't unethically use your technology. So in detailed description, we need to give complete details about your invention, examples of it, different applications of it, ramifications of it, and complete working of your invention. Everything needs to be given in detailed invention disclosure. And these detailed invention disclosures will be explained with the help of drawings. Those drawings, what we have mentioned in section 7, those detailed we try to explain everything with the help of drawings. Most of the times in chemical and chemistry related or material related applications, we generally will not have drawings, but sometimes microscopic view of those materials can also be submitted to, if the structure is more important or the nanoparticle size of it, if it is more important. If something like that is more important, then we need to submit even a microscopic or electron microscopic view of those materials. Generally, for other things, like even if it is for software related applications also, we need to at least file functional drawings or the flowcharts, everything. And for chemistry and everything, normally our experimental studies can be studied with the help of graphs, charts, and everything. Those charts we need to explain in these detailed invention disclosures. And now when it comes to claims, as you all, I think you might have been knowing that the importance of claims. Whatever you write in rest of the parts of specification, either it is in field of the invention, summary of the invention, or statement of invention, objectives of the invention, detailed invention disclosure, whatever it is, you might write anything, but you'll not have right on all those aspects. Whatever you write in claims, you'll have right only on that. It is especially a techno-legal document where we need to take care of the language very much, or very importantly about this claims. And the terminology, we need to be very selective. The sentences or phrases, because any invention or any claim will be a single sentence. So naturally the sentences, whatever we see, we call them as phrases. All those phrases, whatever we write, should be very selective, and the size should be optimum, and at the same time it should be descriptive and meaningful, and at the same time it should have a difference over the prior art. It should have some inventive point or some novel point over the existing thing. Sometimes, most of the times, if anyone is familiar with the patent analytics part of it, sometimes most of the claims will be similar. The same, the washing machine comprises of a basket, a motor. If you see all those parts, those parts will be same in most of the patents. Then why did people file different patents for different patent applications? Will be a question for us, right? So if you carefully observe those claims or the complete one single claim of it, there will be at least a single sentence difference. That single sentence difference is the difference from the prior art. That single point itself is your inventive step, and that should be mentioned in your claims. That is very much important for your patent application, for drafting any patent claim. And whatever the patent claims decides the boundaries of your invention, and it is the heart of your invention, and you'll have right only on those letters whatever you write in this part of your patent application. While drafting patent claims, these are some of the important things which we need to consider. Each claim should be a single sentence, as I said earlier, should be clearly worded. Each claim should be precise and without unnecessary repetition. And rights are given to claims only, not for any matter described in the complete specification. Claims define the boundaries of legal protection, and all these things we have discussed. Each claim is evaluated on its own merit, and therefore if one of the claims is objected, it does not mean that rest of the claims are invalid. That means if I file 10 claims in my patent application, and if the examiner rejects one of the claim, either it can be 7th claim or 6th claim or 5th claim or 9th claim, then it doesn't mean that rest of the claims are not valid. It is that other claims, except that single claim which was rejected, all other claims are allowed, and you have right on all those claims. Normally, how do you draft thing is, these are some of the tips. How do we generally do? We will try to draft while filing a patent application for the first time. What we generally do is, we first do a patentability search, and we will try to understand what is there till date in the prior art, so that we will know the boundaries to what extent we can claim our invention. So first part will be, we need to do a patentability search, then we need to make rough sketches of our invention, and then we will try to write the sentences or the claims depending on the scope my prior art would allow me to claim. So based on that, we will try to claim. And generally, how do we start is I claim or we claim. These are some of the points which you need to know. And the one of the important thing what I'm trying to say earlier also is we need to be very crisp at the same time. Need not be like at the same time we need to be very explanatory also. Why do we need to be more crisp? Is suppose for example if I am trying to explain something, uh, if I try to talk more, I'm giving more, like I'm trying to narrow my scope, or if I'm trying to reduce the scope of my invention. In the same, how would I explain that part is, suppose if I am trying to recruit a person, or if I am trying to recruit people for my company, if I say any engineering student can attend, so naturally I would get more than 1,000 people as applicants. Now I would say that any engineering student who has more than 60% percentage in all the semesters, if I say, I think more than 50% of the people would be deleted from my list. And I would add one more sentence, like I would try to describe my requirement in with one more sentence. So any engineering student with 60%, and he should have English medium in 10th intermediate also. If I say the third line, I'm trying to describe in my requirement in the third extra line. So I'm trying to narrow my scope some more. And at the same time, if I would add one more line stating that those people who completed every subject in single attempt should also only those people should come. That means I'm trying to narrow it more narrower, and I'm trying to focus on to a single very less number of people who would try to qualify in all those sections. So this is a common example to understand why we should talk less, or why we should explain it in a less number of sentences in claims. But in description, we need to be more elaborative. For a single thing, we need to explain it, like earlier when we were trying to see in DD, maybe you might not have seen, in Doordarshan when we have seen, most of the times we would see, I saw a story called where what do you call, dove, or yeah, normally pauram in Telugu. A pauralani, when they try to go in search for food, when a single one goes, naturally when there is a net, the hunter or whoever wants to catch it will catch it immediately. But when next time when people when more number of doves go and try to eat, and when the person hunter who wants to catch hold of all those things, they all together will go. This is if you try to tell the same story, you can try to tell the same story in just 3 sentences. But when I saw in that DD, I saw she will be telling ek chidiya aur ek chidiya aur ek chidiya aur ek chidiya, like that. We need to explain sentence by sentence, sentence by sentence, sentence by sentence, and each and every step in detailed invention disclosure. But the same procedure cannot be implemented in the claims. So while describing in detailed invention disclosure, we need to be very in detail, or we need to be very clear, and we need to support our claims. But while writing in claims, we need to try to talk only the important things, or important sentences, or important key features what we are thinking to be very important should be written in those claims. Generally, when we try to file patent applications, first time we will try to file very broad claims, very broad claims. Then examiner would do the same way what we do here, like he would also do a patentability search there, and he would find some of their references to be more closer. Then he would try to compare our invention with those references, and he would say that this patent cannot be patented or cannot be given a grant because this is very nearer to that. Then based on the prior art he has cited, we can reduce the scope of our invention. Then we can make narrower claims and then get grant of it. And at the same time, so naturally our intention will be, we will try to draft as broad as possible, and we will try to grab as much scope as possible. But when we try to during prosecution, when examiner points out the scope of it with the help of some other references, we generally try to narrow that. Is someone trying to call me? I can just continue. Yeah. These are some of the important things. Like when we try to claim, it should be supported by description and everything. And basic structure of the claim. If you see, a patent claim is composed of three parts. The first part is called as preamble or introductory phase, and the main body of the claim, and the linking words that join. But at the same time, if you see, this is an example, maybe you need not consider it to be a chemical example or something like that. Don't see the technical validity of it. Try to understand the construction of it, only for just an example of it. If you see, this is a method for promoting weight and fat loss in an individual in need thereof. Till here, this we call it as preamble. And this is called as transition phase, comprising. And we will try to narrate rest of the things, whatever compositions we use to reduce the fat loss. So this would be called as main body. The sentences what we have written in red will be called as main body. And the word green sentence is called as transition word. And this is preamble. This is the general basic structure of any claim. Why do we use comprising? So people whoever have listened earlier about claim drafting and everything, you might be very much familiar about comprising. But let me talk a bit more about comprising. Suppose while writing, why can't I write thereof consisting or includes? Why do I write only comprising? Can anyone of you in the class tell me? Does anyone know the reason?
Comprising in the sense like you are trying to include the whatever the thing that has been mentioned, as well as that has to be included. I mean to say, a method of promoting weight and fat loss is an individual in need, therefore comprising. So you're including as an inclusive way, you're explaining there.
Yes, sir. Yes, sir. You're right. Like normally, why do you, like we have while telling, like we said many times, like while using words, whatever phrases you use in claims, we need to be very careful. Like most of the times, if you see our patent claims, you would be finding comprising. When for a common man, comprising or consisting of or includes, all these means the same thing for a common man. But when it comes to legal terminology, it seems that when we say comprises of or comprising of, it means that whatever it includes, not only whatever we have written here, but also the some of the generic things by default which will be covered will also be there in this. By default, which are supposed to be there, will also be covered in this. If I say consists of instead of comprises of, it means that whatever I have written, only those things will be there. Some default things which are supposed to be there will not be included in this. So what are those default things? Suppose, for example, let us consider my invention is a ceiling fan. And when I'm trying to write claims about my ceiling fan, and my invention is more about motor, and naturally even the arrangement of blades is also important for me. Normally, while writing the body of the claim, I might tell that it comprises of a body to hold the wiring or windings of it, and it has blades, and it has a rod extending from the body or of the central body of the moving equipment. Everything I might write, and I might not talk about the rivets which connect, or the connecting means need not be rivets or bolts or screws, or sometimes it can be just a welding part of it, based on the requirement, based on the innovation, based on the our design, we can use anything, right? So those smaller things, those default things, those connecting things, those fasteners, we will not be talking more about it, because my invention is more on windings of my invention, windings of that fan, rather than the rivets or the screws or the fastening elements what I am trying to use there. My invention is more on the windings I use, the number of windings I have, the dynamo I use, or some magnet I use. All those are more important rather than these things. So while writing the body of my invention, sometimes I need not write about those fastening means. Sometimes I might write that there is a fastening means, or I don't even write the fastening means, because by default some fastening means is there. So when I don't write about the fastening means, if I say comprises of or comprising of, by default these will be included. But if I don't use comprises and if I use only consists of, then naturally if I don't use a fastener in my body of the claim, then naturally I am losing a fastener, or fastener will not be part of your invention, or will not be part of your exclusive right. Okay, I hope you might have understood the importance of the transition element what we are trying to do. But sometimes we even use consists of also, where especially in chemical related or chemistry related patents, where the prior art is very very near and our invention is very specific, then, and we wanted most of the times inventor or the examiner would say that this is most obvious thing, when so and so thing is happening, this is an obvious thing for a person who is skilled in the art, and if I try to write comprises, he will not allow me to write that comprising of or comprises of. So then to get my patent granted, then because, and my scope of my invention is very very narrow and my invention is so specific, then I would go with consists of. Otherwise I will try to prefer to go with comprises of. In specification, normally if you see, these are the common things what we generally see: independent claim or dependent claim. For a normal person who is not working in claims drafting or drafting team, normally if you see, if you have an invention and when you go through a patent, normally you would find two things, most common things. One is independent claim and the other one is dependent claim. In independent claim, what we generally see is important, like the complete boundary of the invention will be defined in the independent claim, and complete functioning, like we will not go to the specifics of your invention, or minutest details, we will not go to the minutest details. We will try to claim all those minutest details in dependent claims, and one independent claim will be there. In where the name itself tells that when we say it's an independent claim, it is not dependent on any of the claims given below. It stands on its own. Even sometimes even a single independent claim will be granted and rest of the claims will be striked off by the examiner, and that independent claim itself would stand for your invention or would give you some exclusive right on your technology. So now normally a claim which doesn't depend on any other claim is called as independent claim. And normally when in Indian patents, we are allowed to file or we are allowed to write only 10 claims. In that, one independent claim will be allowed and 9 dependent claims will be allowed as per practice we follow. In law it is not defined, but the patent office practice, what it defines is only one independent claim will be allowed, rest of the 9 claims will be dependent claims. If you want to have more number of claims, it will be like you need to pay extra fees for it and you can increase n number of things. But if you want to have one more independent claim which is not dependent on the first claim or which is not dependent on any other claims, you need to sufficiently safeguard your draft in front of your patent examiner, stating that this is the same invention but the description is more detailed here. And why did we include a separate independent claim? We need to be more argumentative and we need to support before the examiner. Generally, they would say that if it is different, they would when we say an independent claim, they would consider it to be another patent application or another invention, and they would ask us to file a separate patent application. So normally in Indian patent procedure, one independent claim will be allowed and rest of the claims will be dependent claims, and maximum of 10 patents, 10 claims will be allowed in single fees. If you want to have more number of claims, you need to pay extra fees for those claims. So this is an example of independent claim. And dependent claim is, it is dependent on the, if you see this main claim, independent claim, or we generally call in practice when you work in patents field, generally we call independent claim to be the main claim. If you see here, we are trying to describe the method, a method of preparing an electronic device comprising providing, converting, processing, everything will be written here. Now, if you see a dependent claim, the method of claim 1, wherein the nanomaterial, because this invention is about sorry, I think it's a mistake. Okay, so it is a dependent claim. So when we write a dependent claim, generally in dependent claims, if we want to give more specifics about any part what we have disclosed in the body of the main claim or independent claim, we can give specifics of it here. Suppose, for example, A and B are two components which are used for C, as per our earlier example, to synthesize C. There I might write only A, 30% of A or 40% of A, and 60% of B will be synthesized at 30 degrees centigrade to synthesize it to C. That will be written in main claim. And here in dependent claims, A can be sodium, A can be potassium, A can be something else, A can be something else, A can be something else, can be written here. Like here, I'll try to give more specifics about it, and also I'll try to claim more about my invention in dependent claims. Or here I'll try to claim all the ramifications, whatever is possible with respect to the prior art will be written in dependent claims. Normally, omnibus claims are not generally allowed in patent office, but here this is a theory when we say, but here now no patent office is allowing omnibus claims. Here we are trying to claim more rather than just writing comprises of in that claim and trying to claim the default parts. Here we are trying to say substantially as described in the specification, substantially as given in the drawings, something like that. If we are trying to tell, we are trying to tell rather than just that lines whatever we have described in the claims, we are trying to claim more with the help of these sentences. But normally these sentences or these type of claims are not allowed in current day practices. And even the same claims can also be divided as product claim as well as method claim or a process claim. When we say product claim, it can be a composition, as you can see here. Like for example, a composition comprising so and so polymer, multi-amine, multifunctional compound, etc. will be there in this composition. Or sometimes if I try to claim a mechanical thing, as I said earlier, if I am trying to claim about a fan, it is also a product claim. And if I am trying to claim about a laptop, intensity or controlling unit of a laptop, if it is new, then it can also be written as product claim. Sometimes method of pharmaceutical, like suppose for example, if you see here, we are trying to synthesize if the synthesis process is new and if it is not followed anywhere, and a method of controlling the intensity is also if it is new, based on some parameters I will consider something, or especially in image processing techniques and all those things, we will try to control or the method of operation can also be patented if it is new. So there are two important types of claims. One is product claim and method claim. So you can protect method claim as well as product claim. And even the product claim can also be called as apparatus claim or use claim. And sometimes India doesn't allow use claims. When we say use claim, it is like for application. Suppose, for example, paracetamol is for treating fever. And so if someone says that paracetamol can be used for treating cough, let us say, for example, only, it is not possible. But for example, if I say that paracetamol is used for treating cough, in India, for applications, we will not be granted patents. But in US, for even for applications, if it is new and nobody has used it till date, and if you are the first person to use for treating cough, if you are using paracetamol, and if it is if it is treating your cough with the help of paracetamol, for that you will be given a patent. So in India, there are other claims also, like use claim and Jepson claim. All these are claims, different claims of claims. For Marcus claims are generally for structures. If you are trying to claim, those claims will be written as Marcus claims. Called all these are types of claims more useful for patent application drafters rather than just to understand what is a claim.
Yeah,
And
Murali,
sir,
sorry for interruption. Here in the use claim, suppose
yes,
as an example you have given in the paracetamol. Paracetamol is already invented and used in some other country. So now my question here
yes,
is: so by using this paracetamol, so I'm invented. I was invented with the another drug. So then that will be the patented, right? So the
sir,
use
sir.
here is the substance is same, but usage is different. In that case, can we get a patent on paracetamol?
I'll try to explain the same thing, sir. Maybe that is your question. Let us say we know that
Yeah, yeah.
paracetamol is for treating for fever,
Favor.
and now we know
Yeah.
even that aceclofenac and paracetamol is used. When we combine those two, we can treat fever as well as body pains. Especially low fever and body pains
Fine.
can be treated with paracetamol and aceclofenac. Let us say aceclofenac and paracetamol combination is not there till date. So naturally, till date, we know only that paracetamol can be used for fever. So he will be given a patent.
Mhm.
After that, if I come up with this composition, first the examiner would say that we know that aceclofenac is for treating pains, and we know that
Mhm.
paracetamol is for treating fever, and you are trying to combine both the things, and you are getting the same result. So we will not be giving you a patent because it is obvious to a person who is skilled in the art. He would be arguing in that manner. But if you see the
Mhm.
Aceclo Plus tablet, there the percentage of paracetamol or composition of paracetamol, if you see, it is only 325 mg, and the aceclofenac what we use is 100 mg, and we would say that because of using these two, there will be a synergy in it, and it is not just combining both the things, and there is a new use for it. So again, we'll get a patent for it. So sometimes it is might be no new use, but there the compositions are different and the synergy there is different. Suppose, for example, the same 650 mg of what we use, the 650 mg of paracetamol what we use for adults, if the same 650, if it is used for treating cough, it is a new use for a known substance, known composition, known mg. So you will not be given a patent. But if you say that some 750 mg or 20 mg or 300 mg used for treating some disease, if you say, and if you are the first person, we will be given a patent, sir. I hope
Okay.
I,
Yeah, got it. Clear now. So, basically, it means the composition of these two things via a byproduct will reproduce, and because of that byproduct, we got a new invention, new cure. So
yes, sir.
that will be the composition will be patented.
Yes, sir. Yes, sir.
Got it. Got it. Thanks.
Yes. And that's it, sir. And the final part of my presentation is abstract. Any invention, like in any patent, abstract is one of the important aspect. It is similar to like any paper you write. Abstract also, we need to give synopsis of our invention. There we will try to give a single sentence about our invention. At the same time, where it is used, we will try to tell. And everything we need to define only in 150 words, not more than that. In within 150 words we need to describe the basic invention of it. And for PCT applications we need to give even the drawing which supports your invention. Now even for India we are providing even the drawings which support your invention, which gives preliminary idea about your invention needs to be given there. That's it, sir. These are the different sections of patent, as well as important aspects while drafting a claim we need to take care. Now, if you have any questions, I'm open, sir.
Yeah. Thank you. Thank you very much, Murali.
Thank you, sir.
For very eloquently and very clearly explaining the various concepts involved in reading a patent document and drafting the claims. Really, your rich knowledge has helped us to understand this very complex subject. I request the participants, I think they've already raised a few questions in the chat box. Some of them we are trying to answer based on our knowledge, me and Ashok and Anandya. But some of the questions I think maybe worthy of getting answers from your practical experience. Anandya, can you read those questions, few important questions to Murli?
Yeah, sure, sir. The last one is can we patent byproducts from one drug because it is our new invention by analysis and combinations.
Yes, madam.
Ma'am, it is not a question. I am answering to the other person who asked the sir.
And of course, the end of our discussion is also the same, ma'am. Yes.
Yes. Go ahead, Anandya.
Yes, I'm trying to understand. The next question is, can a startup product can be claimed in IPR?
If it is new and the product is new, naturally we need to assess if it can be patented or not. And if anything new or the existing thing, we need to see in what form of IPR we can protect your unique way of thinking, and based on that we need to protect it.
Yeah, as Professor Ganguly mentioned in his introduction, there are 8 types of intellectual property rights. Patent, trademark, copyright, design, integrated circuits. Like GIs, like that. There are 8 types of intellectual property rights. So depending upon the which category it falls, the startup could develop a product. One can always get protection, provided, as Murali says, it has to fulfill the 3 criteria. You all know that the criteria is novelty, inventive step, and industrial use.
Yes, sir.
We need to assess the patentability assessment using these 3 criteria. Now, if there is no pre-art, if there is an inventive step, if there is an application for your product, one can always go for filing a patent. Whether it comes from a startup, it comes from a student, it comes from a research scholar, it comes from a faculty member, or even if it comes from any common man, So there is no bar. Anyone can file a patent, provided his idea, his knowledge, his product or his process or his method or his device fulfills the criteria of patentability. All of you should remember, anyone who wants to go for a patent, his product or his process or his method or his device, these are all the things or a subject matter of patentability or patents. It should fulfill the criteria of novelty. Novelty means first time. It should not be in the public domain at all till that point of time when you file application. So novelty assessment is very, very important. Of course, inventive step compared to the existing knowledge. What are the technical advancements you made by inventing this, and the industrial application. As long as it fulfills the 3 criteria, it can be a patentable. No issue, no challenges. Nobody will ask. See, for example, I always my favorite example is a Coca-Cola can. When you open the Coca-Cola can, it's easy to drink the contents which are there in the Coca-Cola. See, such a simple invention. It was patented, it was commercialized. All the soft drink companies in the world, they use that, the Coca-Cola opener technology. Just you press it, raise it, it cuts and opens up so that you can drink the contents in the Coca-Cola can. He gets every day 2 crores as a royalty based on some assessment, from that simple technology. It has fulfilled all the 3 criteria. What is that? Novelty. Till now, it is not there in the market. Nobody knows about that kind of a opener. And there is an inventive step. Inventive step, of course, majority of it comes from your novelty itself. If it's not there in public domain, that itself qualifies for even indirectly an inventive step as well, and of course it has got the industrial use. So these are the 3 checks all of us need to know if you are interested to go for filing a patent. Yes. Any other question?
Sir, there was another question that we have to present each and everything in the description about our invention. Then how should we point out the thing in the draft presentation by single line heading?
15 words in the title, that's what Murali said. The title
It's
of the
only the
patent,
title.
yeah, it should not exceed more than 15 words.
Only in title.
Only in title. You can explain any number of pages. There's no limit. But you have to pay more money. The number of pages are more, the number of clients are more.
If the number of pages are more than 30, we need to pay extra fees.
Extra. There's no problem. You can write the way you write in exam. As many number of pages as possible. There is no limit on that. But only thing is you have to pay extra money.
So there was another question. Can we modify our invention after patent publication or grant?
Yeah, I think section 54 or I think
amendment, sir. She is talking about amendment.
Okay, ma'am. Normally, amendment generally after filing the application, amendments are not allowed, ma'am. Only claims will be allowed to amend, provided they are supported by the specification. That is the reason why, while drafting a specification, we need to give as much information as possible. As on date, we might feel that single point is very important for our invention, and we will be trying to claim in claims. But when we suppose during prosecution, we might find that that single sentence will not be helpful or will not be sufficient to get a grant. Then generally we use some sentences in the specification which is already disclosed in the specification. Based on that, we can amend the claims. Normally, examiner will not allow us to amend the specification. He would ask us to amend the specification within the scope. Only if he asks us to amend the specification, only then we are allowed to do. And most of the times it is for sometimes when he would allow is sometimes there will be non-uniformity in usage of words, or sometimes some experimental studies will not be included, but the scope is clearly defined. Only in those exceptional cases we will be allowed to add some sentences to the specification. Otherwise, they will not allow us to amend our specification. If there is a clerical error, like for 109, if I have written 110 or some spelling mistakes, only those will be allowed very easily. Otherwise, normally patent examiner would not allow to amend our specification, though we have 59, 57 which support us to amend if provided if the controller accepts. But normally in practice, they would allow us to amend claims, but they will not allow us to amend specification.
See,
even though allowed, it should be before granting the patent right?
No, sir. Once we file, it should be supported by the specification. Somehow, directly or indirectly, or broadly, or may not be directly or indirectly, somehow it should be supported by the specification. Only then we can amend. And if he finds that, if the examiner finds that those sentences can be rephrased, and if he asks us to rephrase, only then we can rephrase. Otherwise, We don't have any right to touch the specification.
So that too in the during the process. So
even during the process, we are not allowed, sir. Once we file.
even the examiner allows. So that should be in during the process only, not after that one, right? Once
Yes,
the
sir.
yeah.
Yes, sir. Yes, sir. Only within the scope, and
Yes.
during the prosecution only, he would allow. He would ask us to do.
Ask us to
Only
allow.
then
Yes.
we will do. Otherwise, we are
Sir.
not supposed to do.
Okay.
Sir, so can
Yes. Yes,
sir,
ma'am.
my question is, after we got a claim, uh, we are shifted to some other country. Can we apply a claim after with some modification from in that country?
Normally, we need to judge the additional content, whatever you have added to the claim, will be sufficient to stand as a separate patent or not, ma'am. First thing. And second thing, if it is in the same country, we can file it as patent of edition, or in if it is in US, we will say that continuation patent or continuation in part patents. There are something like that. Like suppose, for example, you have a patent already in some country, and you want to add some content to the same patent, then we need to judge whether it would stand as a separate application or it would be a continuation to that. Then we need to file as continuation patent or patent in a patent of edition or something like that based on their regulatory things.
Sir, my question is, my first application in IPO. Can I apply the second application UP, US or something to any other country? My patent or modification is good for a
So
patent.
modification, if it stands as a separate application, only then you can go, ma'am. Otherwise, you will not be allowed.
Okay, sir. Thank you.
Improvement, if it is an improvement over the existing patent, you can file as a separate application.
Okay,
Yes,
sir.
ma'am.
I got it.
In another
Again,
patent.
it should fulfill the criteria as I told you.
Yes, sir. Thank you, sir. Thank you.
Any other questions, Anandya?
No, sir, that's all.
That's all.
Yes, ma'am. Someone is there, sir. Yes, ma'am. Yes, ma'am.
Maram Kirtana.
No, ma'am. After 20 years, it is free to world. Whoever wants to use, everyone can use, ma'am. No, we cannot renew. Only in some exceptional cases, especially in pharma, like patent office would not allow. If there is a delay in patent office procedures, they would give you only 120 days extension of patent term, and even WH especially in pharma in US, sometimes because of clinical trials and etc. There will be delay in marketing your product. In those cases, again, patent term extensions will be given, but it is not the patent office. It will be given by Drug Control Board or FDA of US, not patent office.
Okay.
So I mean to say the same owner can renew it by filing after 20 years again to get it patent.
No, sir. Most of the times will not be allowed. The same owner, because of patent office procedure, he is not the patent of delay in patent office procedure. They would allow to a maximum of 180 days or 120 days for the same application. If it is proved that there is a delay from the patent office. In exceptional case, when there is a new chemical entity, altogether a new drug chemical entity has been synthesized, and in such cases, and in some cases where it is for pediatric use, in those cases they will be given to a maximum period of 180 days, and it is governed by Hatch-Waxman Act, and it will be regulated by FDA, not the patent office.
So you meant to say that after 20 years, it is available for entire public and there is no exclusive right on anyone.
Yes, sir. It is a quid pro quo system. You give it for free to the public, and for 20 years, you will have an exclusive right.
Okay.
Okay, good. If there are no questions, probably we can close the session by thanking Murali for sparing his valuable time and sharing his experiences, knowledge with all of us. Only the sad part to me is that only 50 participants are present, though 210 people paid the fee. But I don't know what can change the attitude of our people.
Sir, yes, 123 around were participated, but last question hour they dropped out after.
Yeah.
Sir,
But
because we also
123 are attended.
excuse me, sir.
After the attendance sheet is given, I think they put their attendance and disappeared.
Maybe.
Excuse me, sir. Can I talk 1 minute?
Yes,
Yeah,
ma'am.
please.
Actually, what was the reason to many students leave the classes? We also have other courses, sir. I mean, other SWAYAM courses, and also we also want to attend them. That's why everyone are leaving quickly, sir. So please consider the time factor too, sir, because we also have sem and mid exams then the very next week itself. So we want to manage our time to all these things.
Okay, okay. But
Yes,
anyway,
yes, we understand because we have given the time up to 5:15. So thanks, Kirtana, for bringing it out to our notice. We will see to it from tomorrow.
Yeah, it's a request, ma'am. If it is 1 day, it's okay, but every day we can't write, ma'am. As a student, please understand.
Yeah, we can understand.
But anyway, the recorded classes are available to you. We will make available to all of you, all the registered participants, the recorded version. So you can go through them at your convenient time and write the exam and get good marks so that the certificate would be issued at the end of the course.
Yeah, surely, sir, we
And,
will.
Yeah, thank you, Kirtana.
and a gentle reminder for today's class is that just please let us